Mention page number one.
Just one urgent mention I want to make, my lord. Your lordship had reserved the order with regard to the seizure of the vessel matter, my lord. Now the situation in the vessel is so grim that few of the crew members had to be airlifted to give some medical treatments. We all request your lordship if and we can expect an early order on the matter, my lords.
I'm trying because of the work pressure.
I'm very sorry, my
You have
lords.
created so much of, volume of people.
Lordship, we do apologize for
I'll
it.
try.
Much obliged, your lordship.
And what, any interim order you want?
No, my lords, they have now airlifted themselves. The only problem is that the vacation is ensuing on 18th, and the courts, even if your lordship passes an order, then the courts at Kojang will also close on 18th, my lord.
I'll
That is
try.
much obliged, your lordship.
I want to mention, my lord, item 2, my lord.
Madam, compromise matter taken up 12 or 2 minutes.
12.
Page number one, item 1 to 7.
Item 2, my lord, can you take into after vacation, my lord? There are no step.
Page 2, item 8 to 20.
My lord, item 9, permitted to withdraw. And item 10, I prefer after vacation, your lordship.
And withdraw 10 after.
Lordship, item number 14. I'm seeking for an adjournment, my lord. Let the matter be taken up after vacation.
14.
1-4.
Page 3, item 21 to 33.
One crore, my lord, I have not received copy of the application.
Which one?
14.
14, you give the copy, otherwise next day also it will be adjourned. Give the copy.
Item 27, your lordship, it is compromise matter. Out of 10 lakhs, the compromise amount 8 lakhs are already given. Another 2 lakhs has to pay, your lordship. I pay, your lordship, on 20th. My friend appearing for the OP on 20th, your lordship. 27. Obliged.
Page
Next page.
Page 4, item 34 to 48.
My lord, item numbers 41 to 44, my lord. But I have some personal difficulty before launch, my lord. Can it be taken up after recess, my lord? After recess. No, I understand.
It may not be possible because see
No, I have got one of my own case in consumer court, so I have to.
let it come after this.
No, it is urgency. State, she not police tango pachre gudi. No, 20 तारीख बेलू पड़ोनी से दिन पूरा after recess. After recess,
But by way of a policy, we thought.
No, I am told by the bench clerk, but my personal difficulties. 41, 42.
Page 5, item 49 to 62.
My lord, item number 55.
63 to 75.
Page 5, item
7, 76 to 83.
My lord, I'm in BC, my lord.
Yes.
My lord, item number 55 may kindly be taken up after vacation, my lord.
55.
And item number 75, my lord, permitted to withdraw, my lord. I filed a memo.
You have given a memo?
Yes, my lord.
Okay. Thank you.
Deeply obliged.
Page 7, 76 to 83. Page 8, 84 to 98. Page 9, 99 to 113.
Item 100, permitted to withdraw.
Pardon. May I please, your lordship? My lord, on behalf of Mr. Kosikananda Guru, my lord, item 111 and 112, my lord, kindly taken up after vacation. 111 and 112.
Page 10, item 114 to 123.
My lord, item 120, my lord. There is some defect there. One time to remove the defect and after vacation. Well, another part to make my lord. There is some cost title bhul. The opposite party number 2. Runnu jagar chunna.
Correct. While curing the defect, cure that defect also.
Oblast, madam.
Page 11, item 124 to 132.
Hello, item number 127. You also remember last to the day before yesterday the matter was there. The 81 years lady, the person has filed the petition and complaint case. Lordship can take up this matter today, my lord.
Why are you thinking that I will not be taken up? We'll take it up.
127, that's why I'm saying.
No problem. You please mention it.
120.
It's not
120.
Don't read.
Problem.
That it is lady 81 years and son is.
Yes, my son.
Mentioned.
Yes, ma'am. I will make an answer.
Item 128, my lord. Dispute between two inspectors, my lord, has sent it to mediation. The date has been fixed to 21st, my lord. Can it be after vacation? Interim order to continue. Report.
Wherever I don't say any interim order is there, that should be continued. Some why people are moving up. Unless I say it is valid or anything, it should continue obviously. Some application somebody is moving.
Page 12.
My, pardon to mention, that item 132, my lord. I am for the informant, my lord, wife, my lord. Metro is compromised, my lord. Today not come, and my lord, kindly taken out 15th, my lord, so that he was appear and file affidavit, my lord.
Who is for petitioner?
I am for the petitioner. And there is a interim.
My lord, there has already been settlement between the parties.
That's what he said. The wife will come.
Let it come 15.
66. Let it
60.
I beg your pardon, my lords, for mentioning a matter.
16, my lord. 16.
Beg your pardon.
133 to 142.
133 item.
132.
Any date next week.
Interim order, my lord. Interim order.
Interim order continue. I have given them instruction. Wherever there is interim order, that's continue.
What? 33, my lord. Any date.
133.
137, my lord. I am for the opposite party, my lord. And I have taken consent from the petitioner. So your lordships may keep it after vacation. And interim order is there in favor of the petitioner. So
Interim order.
obliged.
Page 13, 143 to 148.
The small prayer, my lord. 3 years conviction, he is already on bail. Conviction, vigilance matter. Trace admission. Appeal. Any day next week. 362 of 2024.
Criminal appeal.
Criminal.
Trace admission, last week I filed the memo, lordship. Here the urgency is there, anticipated bail was allowed. And the meantime, charge sheet submitted, 307 added, for which the court is not
Do
granting
you
bail.
need an order for that?
With the
By now, all the judges know.
କରୁନାହାନ୍ତି ମାନେ ଲର୍ସିପ ଖାଲି ସରେଣ୍ଡର କରି ବେଲ୍ ଲିଷ୍ଟ ହେଇଯାଉ
Susila Devi, whatever.
yes sir lordship but trial court is not extending that benefit
Pardon to mention, my lord, a urgent matter, my lord, prevention of women from domestic violence act. In-laws are involved in this case.
I beg your pardon to mention, my lords. I beg your pardon, my lords, to mention a matter. It's a fresh admission matter. CRLMC 3013 of 2023. The challenge herein is made to the jurisdiction of the police officer in entertaining the application of the Drugs and Cosmetics Act. The matter has moved to the stage where the learned court below has moved for framing of charges. So, I pray, my lords, the matter may be listed because it is a fresh admission. So, your lord should make.
What is charges? We can wait till vacation.
Well, it's the learned court below. The challenge which I have made is in the jurisdiction of the learned court below also. So now learned court below is proceeding to with the trial of the case, and without hearing my discharge application vis-a-vis the jurisdiction plea, they proceeded with the framing of charges.
Okay, 20th. Give the number.
My lords.
Maybe
I'm moving the matter.
My lord, it is a CRLMC fresh admission. My lord, the urgency is that, my lord, the police officer was harassing my client. We, being the lawyers, sent a legal notice to the police as to inquire what case is pending and why are you harassing our client. Instead, my lord, the police has registered an FIR against the lawyer, my lord. And my lord, they have already apprehended.
This is the story every time.
My lord,
confrontation by the lawyer.
My lord, that is the glaring example of the high-handedness of the police, my lord. It's an unfortunate incident, my lord. Again, ଯେତେବେଳେ legal notice ଗୋଟେ ପଠେଇବୁ, they will implicate us in a criminal case, false criminal case, my lord. And my lord, my lord, yesterday they apprehended my client, made him sit, coerced him to write an undertaking in the police station, my lord, for recovery of some money, which is not even the case, my lord, which is completely a false
Which
case.
police station?
IIC Mahanga, my lord. Mahanga police station. My lord. My lord, this needs.
What is this happening? The law. How can they detain a lawyer like this?
Not the lawyer, my lord, my client. And they called me also, my lord, but I did not respond, my lord.
It will, again lead to some strike and all.
My lord, that is the reason, my lord, it needs your lordship's indulgence in this, my lord. I request, my lord.
But otherwise it will lead to
My lord.
something.
Pardon me to mention, my lords.
Monday.
Pardon me to mention,
Highly
Miss,
obliged.
this matter was listed before your lordship.
Since are also doing this.
So that is the reason. If there is a confrontation between police officer and advocate, then it's very difficult.
Miss,
It
pardon me.
leads to something else.
Pardon me to mention.
Leave that matter as a-
Pardon me to mention, my lords, this matter was listed before your lordship at yesterday's board, but unfortunately it didn't reach. My lords, I'm making a mention, my lords, there's a stay order in favor of the petitioner. Therefore, I am moving a vacation of stay interim application, my lords, which needs. My lords, it's a 138 negotiable instrument act, my lords.
What is the check amount?
My lords, 40,000, my lords, two checks of 40,000, my lords.
Great urgency.
Milos, the trial in, before the learned court below has already.
Notice was issued only to see that the matter is settled. Only 40,000 rupees.
Milos,
My lord mentioned here that item 7, supplementary. Item 7. I am on behalf of the advocate of the petitioner. Petitioner advocate has engaged another case out of Cuttack district. I have no power in this case. My lord, so let it come 7 next week. Item 7. My lord.
Adjourn beyond vacation. Yes, next.
Sir.
Item 1.
Yes.
My lord, here I have taken instructions. Your lordship kindly see page 27, prayer.
27.
Yes, my lord, prayer.
Prayer.
Yes, my lord.
Yes.
Call for record, hearing the party, please to quash the proceeding initiated by OP number 2. So and so. We have not initiated any proceeding against the petitioner till now. No proceeding has been initiated. Only summon was issued. So
Premature.
And we are not going to initiate because in view of Supreme Court judgment in Vijay Madanlal, as the schedule offence has been quashed. So we have not initiated. We have already sought for sent the for approval of the headquarters. So proceeding has not been initiated.
No,
Making a fair statement.
in the fresh affidavit, in the affidavit which I have filed,
He has sent it for approval. It may be, I'll keep it pending.
No, once
The lordship kindly
Supreme Court said
yeah,
that
yes,
the closure of
and
closure
lordship
report
kindly-
will be treated as accepted by the court.
Sir,
Yeah.
They have initiated the process.
We have already
Shall I take it and dispose it up? If
Yes,
any
your
cause
lordship
effect
can
is
dispose
survived,
of.
then, that's a better idea.
We have not initiated any proceeding. We have not filed any complaint. We have already sent for approval of the because
In this petition, petitioner has the petitioner is seeking quashing of the proceeding initiated by opposite party number 2 in April. Mr. Agrawal has conferred the petitioner, opposite party number 2, submits that in fact there is no proceeding initiated against the
petitioners.
Petitioner, as the petitioner has already been acquitted.
Petitioner. Quashed, schedule offence has been quashed.
Schedule offence initiated against the petitioner has already been quashed.
Last paragraph, your lordship. Last paragraph, your lordship.
Yes.
We have sent for
Agrawal
approval.
is placing on the record a written instruction dated 24/2024. The last one, the para 3 of the instruction reads the instruction is taken on record in view of the aforementioned development. The petition is disposed of with the liberty to the petitioner to approach this court if cause of action still survives at any stage.
Obliged.
Disposed of.
Your lordship may say that petitioners.
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 Item 3.
Yes.
Item number 3. Yes.
This is a case, my lord,
Yes.
where charge sheet has been submitted. Your lordship may kindly have a glance at the charge sheet, my lord. Annexure 2.
Yeah.
My lord, charge sheet has been submitted under sections 498A, 304B, 34 of the Indian Penal Code, 406 and 306 of the Indian Penal Code, my lord, and 4 of Dowry Prohibition Act. Now, my lord, cognizance was also taken under those sections, my lord. Now, the charge has been framed, surprisingly, without any material. Charge has been framed under section 302. So, I am against that, my lord, framing charge under section 302, where from the court below got the material.
This order dated 6th April.
See, that 6th April, my lord, postmortem report was called for to find out whether postmortem report reveals anything attracting 302.
Yes.
My lord, I have got my lord copy.
Region. Postmortem.
Today, my lord, I got. My lord.
Today you got it.
My lord.
Have you given?
My lord.
No, but
Actually, I'm not today. My lord.
अच्छी की चीज है
So, what is this? Postmortem report, what does it say?
Not the
इंजुरी की चीज अच्छी की
no, injury चाहिए.
before
Poison का.
हाँ poison, it's a case of poison. 306
poison findings टा pending थला. Outing the my lord chemical examination report, my lord.
अच्छी की चीज
I said acid chemical postmortem थला. First time we listed this matter in this bench, my lord. Earlier occurred coordinate bench is there, my lord. So for yesterday night, my lord, I came to know that a postmortem report is required, my lord. When I gone through the postmortem report, I found that, my lord, the chemical the Mishra sent for chemical analysis report, but that has not come, my lord.
To know the
My lord, real
whether yes.
My lord, that is it.
So get it.
My lord.
Simply
That this
Yes,
issues
ये
are not
inter-
raised, my lord, by so far the chemical analysis report is concerned.
नहीं वो हमें कम
Sema
से
that
पहले
now admit that he has received the postmortem report. The postmortem report indicates that the exact nature of poison could only be known after the chemical analysis report. And the chemical analysis report is awaited, hence the matter will be taken up.
interim order to continue.
Interim order to continue.
Item 4.
Here my petition under section 311 petition was rejected by the court below, my lord. I pray in this case, my lord, before the court below, the council could not put the question, my lord. I pray withdraw the petition, I file a press petition before the court below.
I didn't follow, sir.
Here, my lord, my petition under section 311 CRPC petition was rejected. That on my prayer before lordship that the question, what question they have put, they have not put in the question. That's why I withdraw the.
To move a press application under section 311 CRPC before the court. If such application is moved, the same shall be considered on its own.
Yes, ma'am. Obliged.
Item 5.
May I please, Your Honor? No, although I filed this appeal for the questioning of the entire total proceeding, but my respective submission is there, Your Lordship. They have and accept the present petition or all other court person in this case of religion there. In the case of
You must be the husband.
Yes, no, I'm the husband.
File करतले कैसे? Anticipatory file करतले.
No.
Both the courts.
Then cause for the petitioner submits that although he has challenged the entire criminal prosecution initiated against him, but he is prepared to withdraw his present petition with the liberty to approach the court the appropriate state because of he further submits that the seventh except the present petitioner, all other accused persons in the present case has already been enlarged on bail. Unfortunately, his application for bail, anticipatory bail has been rejected by the coordinate bench of this court. Therefore, he seeks liberty of this court to approach the court below for grant of bail on the ground of parity.
Compromise
On the ground of parity.
Apart
from that, petition submits that the parties have also
he is appearing for
settled their dispute, settled their dispute.
302-493. He the husband, parity.
Parity husband का सर parity.
He say, I'm recording his statement.
substantial.
And so to enter the appearance for opposite party number 2 and submits that indeed there is a process of settlement which is going on. In view of the aforementioned developments, petitioner is granted liberty to appear before the court on or before 30th June 2024 and apply for and avail remedy under law on all the grounds available, including the grounds as mentioned.
So both the courts may kindly dispose of the
Such
appeal
application
same.
shall be considered the same.
Both the courts, both the courts.
So,
Your Lordship, my Lord and Friend, both are very good defense counsel. Whenever they are their side,
you take them
they
this
are
side
playing like
and you
this,
come
what
this side.
I have been waiting.
Item 6.
When you come with after the dismissal of what you call anticipatory bail, it's very difficult. Yes.
Item 6.
The petitioner seeks to quash the further proceeding of the criminal case and the affair matter. And the fact of the case is that the authorized representative of the collector and DM Hon'Ble purchased one strip of gas tablet, Pantocid DSR, from Budhi Thakurani medicine store, who is the retailer at Hon'Ble Bus Stand, Mailer. After taking those medicines, the collector DM suffers from heartburn and serious gastric diseases. Thereafter, he admitted in the Apollo Hospital.
Collector.
Collector? Yes, collector. And so far as the allegation against the petitioner is the wholesaler. I have supplied 10 strip of Pantocid DSR tablet to the retailer.
That's part of investigation. What
What happens, your Lordship, kindly see page 15 of the FIR.
What is the stage of investigation? Investigation is over.
Charge sheet has been filed, my lord. But as per the findings of the charge sheet, 326 is not made out. And the doctor of the Apollo Hospital opined that the cause of heartburn and gastrics, there is no possibility of taking the medicine of Pantocid DSR. I have also a copy of the charge sheet, my lord.
All these things you have to argue.
Raise ballot, raise at time of pending charge.
My lord, because my lord, I am the wholesaler. My lord, I am the wholesaler, but what?
The only problem with you is your medicine is purchased by the collector.
No, my lord. No, my lord. My medicine. Your Lordship, kindly see. Because, my lord, your Lordship, kindly see page 15 of the FIR, my lord. 28/2022 ରେ 10 strip ଆମେ ସପ୍ଲାଇ କଲୁ ରିଟେଲରକୁ। ଆମ ମେଡିସିନଟା ତାପରେ ଯୋଉ ସେଲ୍ସ ଡିଟେଲ୍ସ ଅଛି 13/7/22 ସୁଦ୍ଧା ଆମ ମେଡିସିନ ସରିଯାଇଛି। ତାପରେ ସେ ଅନ୍ୟ ଲୋକଠୁ କିଣି।
Examination report, curious or what?
Yes, my lord. Spurious and counterfeit drugs. But that medicine does. Your Lordship, another thing is that 22/12/2022 ରେ ସେ ମେଡିସିନ କିଣିଛନ୍ତି। ମୋ ମେଡିସିନ 13/22।
All these things can be gone into at the appropriate stage, not in cognizant stage. I am giving that liberty. Right now, let us not for the petitioner seek to withdraw this petition to argue all the points before the court below at appropriate stage. With this liberty, the petition is disposed of. You argue all this point at the appropriate stage. I can't go into all this thing at this stage. If chemical analysis report would have been supportive to you, then I could have given it. It is spurious.
That medicine does not belong to me. That is the question.
That has to be ascertained by you.
Yes, my lord, because the drug inspector says that medicine has been purchased from other persons, other wholesalers.
You show that to the trial court, you may be discharged.
Yes.
Yes. Next.
Item 8.
Item 8, may please. Your Lordship, may kindly see page 46.
46.
440.
Yes.
Lord, page 46, your Lordship will find the informant is at petitioner number 1, Dipti Putti.
46, no?
Annex to 6, no?
Yes.
Your Lordship may see 44 is the cause title, 6, Annex to 6.
44 is the cause title.
Cause title. Your Lordship may see petitioner number 1.
1 is
Dipti Putti. Your Lordship may see wife of Sandeep Jate. That is the present petitioner in CRLMC. Now, your Lordship may kindly see page 47. 47. This is a maintenance proceeding. Page 47, your lordship will see para 1, the brief history. The petitioner number 1 is the legally married wife of the respondent. Their marriage was solemnized on so-and-so by taking vow, exchanging garlands to each other before the portrait so-and-so. And marriage date is there. She says that she is married to the present petitioner.
On
10/7/2018. Now your lordship may kindly see page 54.
54.
Yes. On the page 54 is your lordship will see a order dated 19/10/2022. Towards the bottom of page 54.
Yeah.
This is the same petition which I just read out, your lordship. 54.
54.
Yes.
1 minute.
Yes. Your lordship will find order dated 19/10/2022. That CRLMC 125 proceeding was dismissed on the ground of non-prosecution by the wife. Non-prosecution by the wife dismissed. Now your lordship may kindly see page 17, the FIR.
FIR.
Which has been sought to be quashed. The complaint is at page 19.
Here.
Your lordship may read Mu Dikti Purti. Your lordship may see 6th line from the top. Sundargarh Ruhe.
Sundargarh.
Same octave. Yes. Pratisruti Dele. The entire FIR reads as he promised to marry, did not marry, conceived, refused to acknowledge the child, therefore torture. This is after dismissal of CRLMC. There she says, I'm married and everything. He's not maintained.
Sure whether it is
Yes.
or not. You have
Yes.
put the garland.
And consequences, I was a manager at SAIL RSP, suspended out of service because of this FIR.
The only FIR registered, my lord. Investigation going on, my lord. They came forward here and filed the
This is
not the
absolutely
stage, my lord.
Charge sheet. My lord, my instruction is charge sheet is there. If your
Fine,
lordship
I see.
permits me, let them charge sheet be. It is absolute frivolous. I have been suspended, removed from service. She is not sure whether she's married.
This case, as like, my lord.
We want to be sure whether you are really.
No, I am sure, my lord. I am not married.
Because she says in that paragraph,
Yes.
you read it out at 46.
Yes.
You have garland here and taken to the church.
Wedding
and
vows.
Pretended as if you were married.
And in the maintenance, she says he's staying with the in-laws. There's no in-laws, my lord. There's no marriage.
Complete confusion in your life as well as her life.
Suspended. Consequences removal. My lord, if this is, my lord, my humble.
I'll issue notice. Better you sit down and settle.
Yes. Yes, absolutely.
Quashing may not be possible because you have created the mess in your life, and equally you have created mess in her life.
My lord,
you have projected as if I'm married, staying with her. Thereafter you say that I'm not married.
No.
All this confusion is there.
That is her case. I am very much sure, my lord.
What?
That I am not no way concerned with the lady. Your lordship may issue because she is not pursuing anymore.
Issue notice.
Yes.
Issue notice. Notice. Letter come with.
Yes.
Okay.
Item 11.
My lord, there's an IA. Only stay proceeding till the appeal.
What put in investigation can I say?
My lord, let her come.
Item 11.
Obliged.
May I please your lordship?
Very limited prayer before your lordship. This is a case, the petitioner before your lordship is one of the accused in the case. Various offences in
Send to media.
Yes, but till then,
Both the matter I'm sending media. Perfect.
yes, your lordship. Till next date, your lordship.
12:30. The both the matters are arising out of both the matters are arising out of the claim file. In the petitioners are the husband and in-law.
No husband, your lordship.
Husband.
In first,
in-law
in-law.
of the opposite party member.
Two.
Party number. Then consequently, the petitioner submits that the allegation, there is no, not an iota of allegation against any of these petitioner except general allegation. General allegation without there being any specific or overtake attributed to them, them. Since the matter is arising out of a matrimonial dispute, I'm of the considered view that if the matter is referred to mediation, the same could be sorted out. Therefore, the parties are directed to appeal for the mediation cell. High Court mediation cell?
Yes, sir.
High Court mediation cell, and the coordinator is directed to issue notice to also, and explore the possibility of the settlement, awaiting the mediation report, least in the meantime, proceeding further proceeding into.
So, but it's a
Who are the petitioners only?
Mindless. Notice be issued to the OP2. नहीं है नहीं सी नोटिस देबो केस रे नोटिस इशू नोटिस मैं यस ओपीटू
immediate chapter
obliged
awaiting the
cognizance passing of cognizance.
Charge sheet was nothing is filed. In the present petitioner is taking passing up the cognizance order dated 8/5/2018. However, copy of that has not been filed. On which time is granted to file additional document, adjust. Beyond vacation. Yes.
16.
16 may I please, Your Lordship?
Yes.
Here in this case, my lord,
What is this?
the charge sheet, my lord. Charge sheet देई पार नथले सर्टिफाइड कोटा मागे
File the charge sheet.
चार से पहले करा
देई जे
आवेदन आसो थोड़ा बसे कैसे
Sheets,
नहीं फिर मुझे चार्ज शीट है भेज
the copy of that sheet. Copy of that sheet.
I've also served a copy to my lord.
Serve the copy.
Counter, I will file counter in the counter.
Will file.
Certified copy. I've obtained certified copy. I'll file in charge.
Yes, file. Yes, fine.
17.
So that your lordship. It's a political case. Purely political.
Political case, so therefore after June 4th. Who knows your client may be a minister.
प्रचार हो जाए करोड़ी कुरपर चोप दूर आउस छुट्टी पर रूट
So enjoy the politics now.
छुट्टी पर रूट डेट
Sure. I love it.
ଗୋଟେ ଛୋଟେ house. If not possible, then
He will try without saying we are trying to accommodate as much as possible.
Right.
That is the reason.
because of my fault, my client is now suffering. My lord.
No, that is the reason the least is crossing 130, 140.
नहीं जोड़ा का एबे कौन की fresh जोड़ा नहीं कि जोड़ा अर्जुन है जी जोड़ा entry model अच्छी that can be that is the regular practice of this bar, my lord. Where the entry model has been granted, my senior also knows, my lord.
लीड चले कंटिन्यू कर टुडे आल्सो कंटिन्यू सम
normally तो होगा कि सेटा आश्चर्य नहीं जाएगा आश्चर्य list रो कहने
Wherever there is entry model, I am adjusting.
दिस कोड आल्सो फॉलो
Continuing the entry model.
normally fresh admission उड़ा के आशी जाए fresh admission
That's what I am trying.
so I pray before launch it before vacation any day.
He try it.
Oblige.
Yes.
17.
17.
Yes. My lordship direction, I have already served the charge sheet copy, my lord, certified copy, my lord.
Yes.
Lord. This one, my friend is. Yes. But here, the present petitioners are tribal persons, my lord. They're accused, my lord.
Yes.
The allegation made by the non-tribal person, allegation is that the petitioners forcibly entered into their agricultural land, which is the first land, and that dispute is still pending, and the exclusive right of the petitions over that property. Anyway, the informant who is being instigated by some non-tribal persons, they made this affair that they put petition entered the agricultural land and plowed there forcibly. And when she obstructed, they threatened to take your life. That is allegation. So my question here, the learned tribe, my point of argument here, the cognizance shall be taken by the SDGM. Which should be tried by the special court, section 7, and prior to that also the investigation has to be made by the DSP, Lord, not by the IAO. Lordship, that is the lordship last time called for this charge sheet, Lord.
What was the offense?
offense that is the, yes, 506 is there, or non-bailable offense, or others offense 147, 337, 354 is there, 379, 507, 56, and 140 IPC. Right, but my only point here that whatever the offense, that is a different thing, brother, decide in trial, but here is that the investigation is to be made by the DSP, but that has been made by the IAO, IAS, that I have given that.
There is no such 3SST Act, my lord. If the
No,
section
no.
SCST Act is there, my lord, then only section 7 my lord,
no,
came into force.
no.
And the DSP should investigate and some action.
No,
No 3SST Act.
but here is here the petition of SCST, bro.
The offense of SCST has to be there.
But
Merely because you are SCST, in a murder case, if you are SCST, the DSP has to do it. Unless the SCST Act is invoked.
But
the Act will not be.
Certain sometimes there is no such SCST Act.
Merely because you are accused in an SCST, then DSP has to conduct.
But section,
Irrespective of whatever the offense is.
but section 7.
7
Yes, section.
Why are you reading? Where is the SCST Act?
But the SCST Act is.
Charge not submitted or some 3SST.
No,
FIR also not arrested. Even if FIR arrested, then only the DSP will investigate the case. As per
that's what I asked. What are the offenses? The offenses are IPC offenses.
Yes.
Rightly
there is no STHT offense alleged against you.
No,
Had there been a STHT offense, then
the matter went to special court and DSP will.
But the investigation has to made that the allegation against me, against us, Lord. That is to be investigated. That is to be tried by the special court, Lord. Not.
Where is the question of special lecture? IPC offenses.
The IPC offense is there, Lord. Yes.
Without the petition to approve the court below at appropriate stage with this liberty the petition is 18.
18.
Yes.
The present petitioner is a soldier in Indian Army.
Huh?
Petitioner is a soldier of Indian Army. He was transferred to Hyderabad, madam. Therefore, he was sent a parcel from Uji, Gujarat. Gujarat posting to Hyderabad transfer. The transfer through the parcel his house hold articles managers. And subsequently, phone call was received, and he has not understood the same and faces cyber crime fraud. And in his account, 50,000 has been transferred to the by the cyber crime. And subsequently, he was intimated of the cyber crime police and he was held up.
What is the stage of investigation?
Investigation, my lord. They had not stated anything, my lord.
My grievance is the IO has given a prayer to release the account, transfer the my amount to my account, my lord, which was held up by the cyber crime due to my as per my
These
information.
are all at the very
As per my information,
After completion of the trial, the court can reach at the conclusion of who is the legally entitled to get the aforesaid amount.
investigation is going on and you have come at this.
I have faced a cyber crime fraud. When my parcel was transferred to one place to another.
All these things have to be ascertained.
Yes,
For that instance,
Ascertained. That's the reason the court says that wait till the charge sheet is filed. So wait. For the petitioner seek to withdraw the petition to file a fresh one. After the charge sheet is being filed, if the cause of action still survives. With this liberty, the petition is disposed of. Wait. Don't get. I have given the liberty if cause of action. It may so happen they will give you back.
Only observation to start sheet may be filed within. At least within unknown FR. Cyber crime fraud. That means difficult.
Submits that the investigation is still going on, and the police should make sure that the charge sheet is filed as early as possible. I can't.
I am understood, my lord. That is not otherwise the charge sheet has been doing 1 year, 2 years not filed.
I know you have a problem.
Yes, my lord.
3 copy may be given.
3 copy. You tell them conclude the. He is a victim and his money is stuck. Unnecessary Neither here nor there.
Yes, ma'am.
এটি দেখিলে দেখি কিছু তো করবে।
19.
Same. That's what happened. Same. Item second. 17.
People in the 19 people.
20.
Until also taken out 12 p.m. Parties are coming.
Settlement.
My lord.
Offense?
376.
Pokso.
No.
21.
Kindly pay for transfer of the 20. Senior will agree this matter.
Today is no bar. Just the number of matters of I keep adjourned. Okay. Adjourned.
Okay.
22.
22 may please me, Your Lordship. I am maybe allowed to on VC mode, my lord. Yeah.
Yes.
My lord, I am in the CRLNC. I am challenging my rejection petition under section 239 of CRPC, my lord. Here is the allegation and under 467, 468 and 470 and 425. The thing is that, my lord, that while availing government service, I submitted a fake BEd certificate. My lord, my submission is I have completed in BEd in the year 1997 from Barampur University, my lord. Then the thing is that, and then the on 28/11/2009, it was alleged that at the time of availing the government job, I have submitted BEd certificate, and the DO has instructed him BO to lodge an FIR. Then FIR was lodged, and subsequently I was released on bail. The thing is that, my lord, for a moment, if your lordship kindly see my RTI information under RTI information in the page number. Just a minute. For a moment, your lordship may kindly turn page number 37, my lord. Page number 37.
What do you want exactly in this case?
My lord, quashing of my rejection of my discharge petition, where I have no prima facie case has been made against me. Your lordship may turn to page number 37, where it is clearly written that
you want the court to rely upon some document you have obtained by RTI. Those documents has to be.
No, it is not only it is, but it is true fact, my lord. Because in the year 2009, an FIR was lodged by Barampur University that the certificate from the year 1997 to 2000 has all were burnt, my lord. So her original records are not available. Then how my records are verified, my lord?
You will be acquitted.
Sorry, my lord.
You will be acquitted.
Then, your lordship, why my discharge petition was not considered without verifying the facts and circumstances, my lord?
The trial court is right in saying that I can't conduct a mini trial at the time of framing of charges, relying upon some document you have obtained by through RTI.
Yes.
What is wrong in it?
Then,
And you also know. By now you also know that the order is correct.
No, not correct.
Holding it tough brief, you are arguing, it's all right.
I only say that where I have never submitted any BEd certificate. My submission is how
when was the FIR?
FIR was lodged in 2019, my lord. That is page number.
Show me the charge sheet. How many witnesses are there?
Charge sheet, my lord. It is in page number 20. Just
tell me how many witnesses are there.
There are, my lord, there are 17 charge sheeted witness, my lord, and
17?
out of them.
Yes, ma'am.
17.
Yes.
And
Yes.
Now what is the stage?
Stages trial is going on, my lord, and earlier I was filed a CRLMC where I had granted liberty to file discharge petition under section 239. But when I filed, but the same was rejected, my lord, on 35.
I see no merit in your petition, but the only thing what could be done is we can try and expedite the trial, because in fact the university says that all the documents are already burned.
Yes, my lord.
Perhaps it's very difficult to ascertain.
That's a let to be felt the trial. If anything, then liberty may be done.
Till now, I'm facing the trial.
What best could be done is expedite the trial. There is no material. Everything is burned. No material is there. She has lost the job.
Yes.
But technically, she has to face the trial. So I'll expedite it.
Yes.
So that
May I pray for further stay of I need to take some further instruction. No, I'm not asking for stay, my lord. No, I'm not asking for stay, my lord. I need to take further little sort of instruction. Your lordship may can the matter be taken on Monday, my lord? Because just yesterday I tried to talk to the petitioner but could not contact it.
Monday again you will try. If the court will not agree, again you will ask for adjournment.
It's a phrase matter, my lord.
I'll tell you, the best thing is you take an order from this court expediting the trial so that we'll get out of the problem. No court is going to give the relief in this petition because the trial court is correct in saying that I can't conduct a mini trial at this stage, and you are relying upon some document. Those documents you have obtained from RTI, that those documents have to be tested in the trial.
My lord,
I'll just expedite it.
no, your lordship, as your lordship, very much correct about this order we are giving the. No, I just wanted the matter to come again reheard on Monday because I have to talk to the petitioner.
Beyond vacation.
On Monday, your lordship.
Monday, no question. Beyond vacation.
No, lordship, any day in next week because I'm trying to contact the petitioner. Next week, my lord. Deeply obliged.
Exciting. Huh? Sorry. 20?
23, may I please, your lordship? I am challenging the cognizance order under Annexure 2.
That matter. You can't waste time like that.
Your lordship?
I wanted to give him doesn't work. That's what here.
Your lordship, I am challenging the cognizance order under Annexure 2, page 15. Order dated 9/1/2024, where the petitioner has been implicated under section 341, 323, 5062.
What are the grounds, sir?
Your lordship, in 3 lines I'll say the fact and 3 lines I'll say the ground. The case is regarding a vengeful FIR. Informant here in this case is the mother-in-law of the petitioner's sister. Mother-in-law of the petitioner's sister, where my lord will see Annexure 3, page 17. In page 17, the petitioner's sister, who is the daughter-in-law of the informant, she had lodged an FIR first regarding Dowry Prohibition Act, regarding cruelty. My lord will see page 17. She lodged the FIR first under Annexure 3.
Against her in-law.
Lordship?
Against her in-law.
Against her in-laws. Against her in-laws.
Yes.
Where the mother-in-law is implicated in that case, and she is the informant in this case, which is a vengeful case, where in Annexure 1, the date of FIR under Annexure 3 is there 13/11/23. The date of the 1cc case is 17/11/2023, where the informant, mother-in-law, who has been implicated in the first case, she has lodged this FIR as a 1cc case.
Your sister implicated them.
Yes.
She implicated you.
She implicated me she implicated me. It's a cross FIR case. She has implicated the entire family of the daughter-in-law, the victim girl, who were not on the spot because
it's a fight between two families.
It's a fight between two. My lord will kindly see. My ground is the present petitioner. I have filed 2 CRLMCs. One is the family members who live in the village. One I have filed for the brother. The brother having a job in Bhubaneswar is confirmed by the email of the job descripant, the job owner, that he was not present at the spot on the day of occurrence. He was there. I have the copy of the email. That time I was not having, sir. First ground. Second ground, by bare perusal of that 1cc case under Annexure 1, there is not my name mentioned at all. Prasanta Das, nowhere. In the 3 pages FIR, nowhere it is mentioned. Family members lekha and I have been, all the family members have been implicated.
What happened to the FIR filed by your sister?
Your lordship, I will show.
No, you tell me.
Your lordship, I have it because.
Just tell me what happened. What is the state?
Sir, charge sheet has been filed in that case. Charge sheet has been filed in that case. I have filed in the second petition.
Contested matter.
Yes, a contested matter. Sir, in my third ground, I humbly pray My
You
third ground,
on merit you don't have a case, but I'll issue notice.
sir, my
that
third ground is a very
dispute
important,
between two family.
sir, my third ground is very important research.
What is that?
Sir, kindly. I have, sir,
Alibi.
no, sir. Sir, my lord, in the placid term of this case is it's a 2023 case.
Yes.
Sir, kindly, I'm just trying to convince my lord. Even if no merit, if my lord will be convinced, then probably any direction may be issued which will be unique.
Yes.
Sir, the placid term of this case is when accused, it is in the live law only, it's reported, sir. I'll read the placid term first. When accused seeks to quash FIR on a ground that is based on personal vengeance, sir, it is justified that it is personal. In 4 days, they lodged an FIR. Attendant circumstance must be looked into. It was held by Honorable Supreme Court, page 20, paragraph 26. Sir, paragraph 26 is very important. Sir, kindly let me place it. Sir, whatever order my lord will call.
How will I arrive at a conclusion that is vengeance?
Sir, it is there, sir. Because, sir, I lodged an FIR of 498 Section 4 DP Act against the in-laws. They have filed immediately 4 days later. Sir, my date of FIR is 13/11.
What are the allegations in this FIR?
Sir, allegation against me? Sir, present petitioner. Sir, 341, 323.
No, what are the factual allegations?
Sir, factual allegation in the sister's FIR.
Against you in this case.
Sir, they are saying that I was in Bhubaneswar. Again, I'm talking about the present petitioner. Sir, I'm working there. They are saying that we came to their house. We barged into their house, created a mess. We physically assaulted.
The matrimonial dispute, you are the...
Sir, this...
You are from the daughter's side. You might have gone there, might have done it.
Sir, this...
How will I conclude that it is in vengeance?
Just one paragraph. Big paragraph, kind. At this stage... 26, page 20. At this stage, we would like to observe something important. Whenever an accused comes before the court invoking either the inherent powers under Section 482 of the CRPC or extraordinary jurisdiction under Article 226 of the Constitution to get the FIR or the criminal proceeding quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive of wreaking vengeance, then in such circumstance...
These are fact to fact different. See, apparently you yourself have said there is a dispute in the matrimonial home of your sister. So therefore, you might have gone, who knows it?
The decision was changed. Why not it will consider so far the information is concerned?
The same thing.
Sir, good a second. Sir,
I'll simply issue notice without wasting time.
Sir, I'm not...
Because what will you achieve?
Sir,
You have partly convinced me.
Sir, I am trying to, because this paragraph... Sir, the complainant would ensure. Sir, they have written the
complaint. You want to dissuade me from not issuing notice?
No, sir.
I'm issuing notice.
I am also seeking for a stay.
They have what? Investigation is going on. How
Sir, I'm in the cognizant stage. Sir, I'm in
can't do that.
Subject to second FIR.
So these are the offences where you might have got the bail.
Sir.
So then
Sir,
I can't stall the investigation.
Sir, only one small line only. I will just read that the complainant would ensure if it is a vengeance FIR, it is written. The complainant would
arrive at a conclusion that it is a vengeance FIR.
That they will make.
You yourself have said that your sister has initiated some proceeding against her in-law. You might have gone and started fighting. How do I know? It has to be tested in the trial. I'm only issuing notice. Because it's a fight between two families, it may be sorted out.
Yes.
It may be sorted out. So that's the idea of issuing notice. Otherwise, you don't have a case.
Sir, I am not presenting now the case, but what is written in that? What is written?
Issue notice. Let us see. Have you item 23, na?
Merit.
Huh?
Merit 23.
But you have argued very well.
Sir.
Yes.
I just wanted to say one thing, sir. Not presenting.
Keep it up.
Not
keep it up.
It is written
save your energy, you will argue.
Sir, it is written in that judgment that a vengeance FIR is written very carefully by the complainant who is initiating an FIR to take revenge. It is written in. That is what I wanted to show, sir.
Better save the family life of her sister by settling.
That's what.
Okay.
Obligation.
Yes. Just 1 minute. Give me a constant.
I talk about 21, the case of 498.
Yes. 21.
Husband and the lodge.
We are.
No, 21 somebody mentioned. We are at 23. 21 somebody mentioned. He mentioned.
Passover.
Passover. Oh, then I agree. Because looking into the
Passover, but it can be
very urgent matter.
Yes, it's a case ballot 498A. Ballot, I filed a divorce case. She has
498 generally I will issue notice.
Ballot may issue notice, fix it for mediation at Gatak and stay the further proceeding.
What is the 21st? Matrimonial dispute also.
Matrimonial dispute the same.
Same. Yesterday also ballot was pleased to.
Not today, two cases here also.
Matrimonial dispute I generally do.
That should be. First attempt should be.
What best could be?
High Court.
High Court decision.
21. The petitioners are in-law.
In-law, husband and in-laws.
71 year. The instance of opposite party number 2, FIR number so came to be registered against the petitioner. This is a matrimonial dispute. The petitioner is challenging the petitioner in this petition is seeking passage of the entire criminal proceeding. This being a matrimonial dispute, all efforts should be made to see that the dispute is settled amicably. Mr. DP probability of out of court settlement. Hence, he requests to relegate the matter to the mediation cell. The parties are directed to appear before the mediation cell on the date to be fixed by the coordinator of the mediation cell, mediation section, and issue notice to the parties. Issue notice opposite party number 2, returnable and returnable and immediately after vacation, awaiting the mediation. In the meantime, the
petitioners are only in-laws ballot.
In the meantime, the further proceeding is told to told. Make an effort so that
Yes.
Filed because the victim married to somewhere else, but there was
Purchaser of the land, they have been additionally added in the.
You want that the prosecution against the uncle should go on.
Uncle, sir, he did not come, but the civil suit has been, but the same term condition has been closed, Miller.
No, you want to proceed against the uncle,
Miller.
but in so far as the other two accused persons, those who have been,
Yeah, the petitioner is purchaser, my lord. They are bona fide purchaser, my lord.
they are the bona fide.
Yes, my lord.
Why are you against your uncle?
He did not come, Miller. And others dispute are there, and he also not return the other properties to the other course.
You want to settle the other dispute by arm twisting your uncle.
No, this petition, this case has been initiated only the complaint petition. Miller. The complaint petition tagged with the GR case.
Charge sheet submitted.
this
is not the GR case.
ଆମେ
complaint
କେବେ mention କରିବା ନାହିଁ
It is a separate
कि
case.
the complainant has settled the dispute against this petitioner's qua.
That's right, but
ସେଇଟା କରିପାରି partial qua ହେଇପାରିବ କିନ୍ତୁ subject to condition he has to compromise the fact with all the accused persons. He cannot choose. He is not the authority. He has no authority to
Maharaja
choose.
says you partially it can be quashed. If the two accused person comes and settle the dispute, it's all right. But the entire proceeding has to go, and the other accused persons they might not have come. They will come and that.
They may come.
This is not the decision, Lord. That is the decision.
Show me.
That is why that yes.
Show me the
Yes.
Both the Supreme Court judgment will not it is the only respect of the persons come and was that against the only the appellant number, the respondent number.
And they settle the dispute in toto.
Only not the Supreme Court judgments is here.
Which paragraph?
Last.
Paragraph.
The first one, the Justice Sadas from judgment. Last paragraph. Yes. In the light of the principles mentioned above, in the advances that to
Okay,
complete
good decision.
find the affidavit and highlighting the stand taken by the applicant. The nature of the need to report the court to the judge of the affidavit by applying appellant. So far as the appellant is concerned. Yes, next.
No.
Huh?
Your lordship is holding decision of Thanga Palai Kumar.
That is Supreme Court judgment.
କୋଉଟା ଦେଇଛ?
ଯୋଉଟା କାଲି ତୁମକୁ ଦେଇଥିଲି ଗୋଟେ।
ନା ମୁଁ ତ ସବୁ ପଢିକି ଆସିଛି।
Yes, yes, which one?
ଆପଣ କଣ ମୁଁ ଖାଲି ଆପଣଙ୍କୁ ଦେଖଉଛି
ନାଇଁ, ଏଇଟା
ଥାଙ୍ଗା ପଲାଇ ସେଇଟା ଦେଖନ୍ତୁ ଟିକେ ଥାଙ୍ଗା ପଲାଇ ଗୋଟେ ଡିସିସନ ଦେଇଥିଲେ
ତେଲେଙ୍ଗାନା ହାଇକୋର୍ଟ।
ତେଲେଙ୍ଗାନା ହାଇକୋର୍ଟ ବେଞ୍ଚ ଅଫ ମାଡ୍ରାସ ହାଇକୋର୍ଟ ବେଞ୍ଚ ଅଫ ମାଡ୍ରାସ ହାଇକୋର୍ଟ।
Yes, what does it say?
Your lordship may kindly see here this case next page 6 point number 6 point number 6. That's you got it?
Yes, sir.
Point number 6.
Yes.
At this juncture, it would be appropriate to refer the judgment of the Hon'Ble Supreme Court in the case of Lovely Salhotra and another versus State of NCT Delhi and another criminal appeal number so and so, wherein it has been held that a affair can be quashed in part on the basis of the fact of each case, and when one of the accused has offered to settle, one of the accused had
What
offered
was the
to
offer
settle.
there? What was the effort?
468, 478.
Yes.
This is the placid amalad though. When one of the accused offered to
But
settle.
here the problem is what he says is, in so far as the uncle is concerned, the charge sheet was filed.
Yes.
And they filed protest petition and drop in these two
Yes.
bona fide purchase. Quasi bona fide purchase, they want to settle the dispute. And that charge sheet thing will go on. The complaint thing will go. They want to
complaint case. It is another case, not the GR case.
Right on. At the instance of the opposite party number 2, FIR number so and so, FIR number so and so,
Affidavit you can take on record.
registered against FIR was registered against all of them.
No, my lord. This petition not named in FIR, my lord.
FIR was registered against
Uncle and others.
accused against what is the name of the person against whom the FIR
Sangram cases Rautray.
Huh?
My lord, FIR was lodged against Sangram cases Rautray, Srinath Lenka, Nirakar Naik, Vishnu Naik, and others.
लिख लो तो ना
Page 13, my lord.
FIR
Running
was
page 13.
registered against so and so. After investigation, the charge sheet was filed against
Sangram cases Rautray.
Sangram
Kesari Rautray.
Sangram Rautray. Sangram Rautray.
Sangram cases Rautray.
Sangram Kishore Rautray. Agreed by the same, the petitioners agreed by the same, the opposite party number 2 filed a complaint case being 1CC case number 2 about 2023. After the statement of the complainant, opposite party number 2, recorded under section 200, the cognizance was taken against the present petitioner, and they were summoned to face the trial along with the GR case pending against what is his name?
Sangram
Kishore. Right.
And both the cases clogged.
It is alleged that next follow. It is alleged that the Sangram Kishore Naik, who is the uncle of the Rautray, who is uncle of the opposite party number 2, has forged the document and sold the property to the present petitioners. The present petitioners, the learned counsel for the petitioners submits that the present petitioners are the bona fide purchaser of the land. The opposite party has now settled the dispute with the present petitioners, who appears to be the bona fide purchaser of the property in subject. Mr. Maharaja, learned counsel for the state, submits that the FIR, the present case cannot be allowed qua the petitioners. The criminal case proceeding cannot be qua the present petitioner alone in the absence of a settlement in toto with all the accused persons. To contravene this position, learned counsel for the petitioner relying upon the judgment of the Supreme Court in the matter of Jayasingha Digvijay Rana so and emphasize is supplied to para 10 and 11. 10 and 11 of the petition. Taking into consideration the aforementioned peculiar facts of the present case and the judgment cited at the bar, I am of the considered view that insofar as the present petitions are concerned, they being the bona fide purchaser of the land, and the opposite party has settled the dispute. The complaint case against the present petitioner could be quashed separately. Could be quashed independently without expressing any opinion regarding the pending GR case against what is his name? Sangram Kishori Naik. The parties have filed the joint affidavit dated so before this court. Before this court, inter alia stating that they have settled their disputes, and the opposite party number 2 is not interested to prosecute the present petitions. Those who are the bona fide purchaser of the land, claiming to be the land of the opposite party number 2. Opposite party number 2. The parties are present before the petitioners, and opposite party number 2 are present in the court, being represented by the respective counsel and identified by them. They have also filed the self-attested copies of their respective Aadhaar card to establish their identity, which are taken into court. Taken into court. Taking into consideration the particular facts of the present case and relying upon the judgment of Gyan Singh and Joshi, I am of the considered view that the petition be just married, and accordingly the complaint case, 1cc case number 2 of 2023, pending before the court of JMFC 4 Kotak, qua the present petitions are quashed. Yes, next. Yes.
And the opposite party number 2 has also filed an affidavit to that respect that is already on record, Your Lordship.
Sorry?
The opposite party has already filed an affidavit.
See, Mr. Maharaj, just speak. What is this? FIR 420.
Lords,
Yes.
20 allegation of cheating of rupees 23 lakhs.
25 lakhs?
For a
Purchase of land.
purchase of land. Accordingly, 23 lakhs has already been paid. That what will- Yes.
25 lakhs you have taken.
No, actually 23 lakhs we have taken.
FIR hଉଛି 25 lakhs, but they have settled 23 lakhs.
No, no, 20, what is the allegation? And
Allegation is has taken.
petitioner has taken 25 lakhs to sell a land.
Yes.
To sell a land.
Yes.
And he has not sold.
Not sold, not registered. That is why the.
Right. At the instance of opposite party number 2, FIR number so shown the petitioner. The allegation against the petitioner in the FIR is that page 3, para 2. The charge sheet was filed?
No, Your Lordship.
Investigation?
Investigation in the present case is still on. At this stage, the parties have settled the dispute. The
Lordship.
dispute is arising out of a financial dealing, financial and land dealing. Financial land dealing. The parties have settled the dispute, and opposite party number petitioner has paid 23 lakhs.
23 lakhs.
23 lakhs to the opposite party number 2. On the said terms, the parties seek indulgence of this court and seeking quashing of the entire criminal prosecution initiated against the petitioner by the opposite party number 2. Petitioner and opposite party number 2 are present in the court, being represented by the respective counsel and identified by them. They've also filed their self-attested copies of their Aadhaar card,
Yes.
which are taken on record to establish their identity. Mr. Maharaja, the counsel for the state submits that the dispute is inter se party, and since they have settle their dispute, and opposite petitioner has already paid 23 lakhs rupees to opposite party number 2. No opposite party number 2.
Yes.
The opposite party number 2 is not interested to prosecute petitioner anymore.
Yes.
Hence, there is no legal impediment to pursue the FIR.
Intersect dispute.
That I read.
Yes.
Taking into consideration Gansing and Joshi, subjecting the petitioner to criminal prosecution, would be a futile exercise. Hence, the FIR is passed. Yes.
24.
No, 1 minute. You have monitoring you pay to the bar. You have to pay to something to the bar.
Welfare fund kichi diyantu kichi heyni.
You, in any case, 25 lakhs you have taken, 23 you have paid.
No, Lordship.
When you had 2 lakhs rupees, you
Lordship, no,
have earned 2.
no, Lordship. Only the record.
How much you will
books
pay?
Only
Okay.
through NAP.
How much? 5,000?
Lordship.
5,000. Subject to petitioner paying 5,000 rupees to High Court welfare fund. Pay 5,000 rupees. Yes, next. 24. Give it to bar. 24. We are very slow.
Made procedural as well. Here, my lord, the
Yes, sir.
it is before my lord is the husband, and he has challenged the proceeding initiated against him
Yes.
by the opposite party. My lord, the fact that my lord, there was a sort of distinction between them, for which petitioner has filed a divorce case, the family court, Baleshwar. My lord, may see annexed to CP number 34 of 2013.
We are seeking quashing of the entire proceeding.
My lord, here, my lord, the divorce case was allowed by judgment dated 17/3/2016 by
Who are you? You are the
husband, my lord. And against that, challenging the judgment of Judge Family Court, opposite party preferred a Matta case before this Honorable Court.
Right.
Annexed 3, my lord, Mishi.
Yes. That's pending.
That was dismissed.
Okay.
Dismissed by this Honorable Court.
Yes.
And as per the order, I paid rupees 25 lakhs to my wife under Annexure 4, pay 67.
Permanent alimony.
My lord, may see pay 67, the memorandum of receipt.
Yes. I issue notice.
Yes, my lord.
Issue notice and say.
Yes.
Issue notice.
Let her appear later.
Mr. Dhal, counsel for the senior counsel for the petitioners submits that the marriage between the petitioner and opposite party number 2 has already been dissolved by an order by a judgment dated 17/3/2016 passed by the family judge Baleshwar in CP number 34 of 2013. The said order was assailed by the opposite party before the appellate court and appellate court unsuccessfully by judgment dated
that is by
judgment dated
16th May
2023. The division bench of this court in Mata number 46 of 2016 affirmed the decree of divorce.
Increasing 15 lakhs.
In lieu thereof, the petitioner has already paid
25.
15 lakhs.
25 lakhs has
25 lakhs.
Out of 40 lakhs.
25 lakhs out of the 40 lakhs awarded towards the permanent element. Issue notice to opposite party number 2.
It has already, sorry, 50 lakhs has also been paid.
He has already paid 25 lakhs, na?
40 lakhs.
Totally you have paid.
Totally I have paid.
Right, instead of right, he has paid 40 lakhs towards the permanent element. In the present proceeding, petitioner is seeking the quashing of the criminal prosecution initiated against him by the opposite party number 2. Issue notice to opposite party number 2, returnable censure. In the meantime, proceeding before trial court state. Yes. 25.
Next. In this case, of a cognizance matter, offense under section 3 506 matter.
Yes.
In the meantime, compromise already
bring them.
My lord.
Keep it up.
Unnecessary 3 matter. But due to illness, informant matter.
Where 20th? When will you bring?
Next week Tuesday, man. Informant देह खराब है
16. Okay.
16th. Oh,
Next.
26.
Yes.
26.
May I please, my lord. Lordship, I am in BC, my lord. Lordship, in adjournment 26, I am praying for an adjournment, my lord.
Adjourned. Yes.
28.
Yes, sir.
Challenging the order under Annex 3. Order taking cognizance under Annex 3 on page 23.
Yes. What is wrong in it?
That's the case arising out of a one-six case.
Therefore, it is wrong.
No, your lordship. While the present complainant, informant, as working as a Anganwadi worker, the present petitioner filed a complaint petition as well as before the appellate authority.
What are the grounds to attack the cognizance order?
Your lordship. The case filed by the present informant is totally false, your lordship, because the informant was engaged as an Anganwadi worker. Against them, the petitioner filed an appeal before the appellate authority. Thereafter, the appellate authority discharged the present informant. Being aggrieved upon and engaged the petitioner as Anganwadi worker. Being aggrieved upon the same.
All these things, how can I go into at this stage? It may be your defense.
File a complaint case, then there are
right. You are correct, but these are the defenses you have. But at the stage of cognizance taking,
in the meantime,
how can I go into all these things?
In the meantime, there are some compromise going on.
Come to that.
Yes.
Have you settled?
Yes, your lordship.
What are the offences?
Offense is 420,
458,
468. Alleging that I have submitted a forged document.
Forged document for what?
For engagement of Anganwadi worker. No money, only forged document for.
And also for the petition submits that the parties are in the process of settling the dispute.
Yes,
inter se, settling the dispute in therefore he seeks indulgence of this cause. We should notice to opposite party. Yes. Yes.
Opposite party.
Next.
Sir, 29.
Yes. Next. 29.
Minor stay for the cause.
That cause for the petitioner would move appropriate application before the court below seeking adjournment in view of the fact that the matter is sub judice before the court and the parties are attempting to settle the dispute. Okay, okay. Next.
Your lordship, issue notice opposite party number 4 and 5.
4 and 5. Okay.
Next.
Yes, next. 30. 29 adjourned.
After lunch.
Which one?
29.
No, today no question of what?
Because of personal appearance is there.
Personal appearance of whose personal appearance?
The petitioner and opposite party number 2.
Are they here?
Matter.
Settled.
Matter
settled. 29.
Matter. Mr. Fonda is engaged in code number 5 for death sentence reference. Let it be.
For them, what is the offense? If it's settled matter, what Mr. Fonda will do? Simple pass.
498A, 304B, 306, 406.
All them. All them, what Mr. Fonda will do? You handle it. They've settled the dispute.
Yes, madam.
All them will see. Next. 13.
30.
I may be permitted to
withdraw. Here. 31.
31.
May I present?
Yes, sir.
Directed immediately adopted in 78 of 24 passed by the learned exigent Jackson in rejecting the petition on different.
Please use the mic. Please use the mic.
Rejecting my petition under section 205 minor.
Yes.
I am a government servant and I am working as an assistant engineer, presently working
Raigad.
at Raigad mine.
Yes.
And
Where
the
is the
distance,
case? Where is the case going on?
case is in the court of law and SDGM Jagatsinghpur mine.
What are the offences?
Offense number 409 mine. And I
What
have
are the allegations?
my lord, sir.
that during my tenure, while I was working at Jagatsinghpur, some funds were misappropriated by various people, and my name was also included. I was a technical.
Show me the impugn order. Show me the impugn order. Why it is rejected?
Impugn order is there, my lord. Impugn order is.
Just check it up. This impugn order, Mr.
Impugn order. Annex
How-
3, my lord. Annex 3. 31. My lord, during investigation of the case, I was granted bail by the London magistrate pursuant to the order passed by this honorable court. And after submission of charge sheet, I was summoned to appear. At that time, I filed a petition on the ground that
205, on what ground you have moved? You said that you were
yes,
suffering
ma'am.
from.
I am a heart patient vandal, and I have undergone heart
Medical document
operation.
you have filed.
Undergone operation since 2022 operation ହେଇଛି, and at present I am also suffering from spondyloreactive arthritis. I am not in a position to properly move. So on those grounds, I filed a petition that it will cause much hardship to appear in the court covering the distance of 450 kilometers.
What, see, the operating part, you come to the operating part.
And the ground stated by the London magistrate, your lordship will find the only ground since you are coming to Bhubaneswar for treatment, what is the harm in appearing before this honorable? What at the time of necessity I am coming.
Yes.
Not regularly I
yes.
cannot come.
Just see, he is posted there in Raigada.
Yes, madam.
And he is suffering, admittedly, he is suffering from many diseases. And
yes.
he needs a support to work also.
Surgery,
Trial court rejects 205 only on the ground that he is coming for treatment to Bhubaneswar. Why can't he come to Jagatsinghpur? What is
Exactly. That is yes. This fact is covered a direct decision of this honorable. Even the London magistrate didn't cite that decision, I have also filed.
Yes, Mr. Raut, have you seen it?
Nobody is going to be prejudiced, my
It's a
lord.
harsh case.
Let us see your concern.
Very harsh.
Surgery document 36 बता
The petitioner is agreed by the order dated 28/3/2024, whereby his application under section 205 CRPC has been rejected. Petitioner is an accused in FIR number. Where is the FIR?
PS case number, Jagatsinghpur PS case number 289 of 2003, and that corresponds to GR case number 799 of 2003, pending in the court of law and STJ. Jagatsinghpur.
Petitioner is working as a engineer.
Yes, my lord.
Assistant engineer and posted in the rural works department at Raigada. Due to his ill health and due to his ill health, and he is posted at Raigada, he could not appear in the court. Therefore, he moved an application 205 CRP. The learned court below, while impugn order dated so-and-so, rejected the impugn order dated 2083. Yeah, Chobiji. Rejected the application while interim recording agent. Recording agent. Ye page 38. 38 of para 1 heard the submission. Sorry. Sorry. 39. 39 perusal on perusal of the petition. Right. The learned court below has rejected the application solely on the ground that the petitioner had been visiting Bhubaneswar for his treatment repeatedly. So therefore, there is no inconvenience for him to come and appear before the court at Jagatsinghpur. But the fact that the petitioner is suffering from various ailments, and is under treatment in is under treatment is not disputed. And the fact that the petitioner is posted with Rayagada is also an admitted fact. In view of these two grounds, the petitioner deserves the petitioner's application deserves well. Keeping in regarding head to the aforementioned fact, the impugn order is set aside, and the petitioner is directed to move a fresh application, raising all these points in the report below. If such application is moved, the same shall be considered. And it is made clear that as and when the petitioner is required to appear before the court, he shall appear without impeding the smooth trial of the case. With this observation, the petition is.
I pray that the NBW has already issued because
When
that
is that NBW? In view of the aforementioned, the NBW issued against the petitioner by the order dated.
by the order dated order dated 1/5/2020.
1/5/2024. Yes, sir. Yes.
Urgent copy.
Yes, next.
32.
May I please? Your Lordship?
Yes.
This petitioner is the principal of Saudwar Women's College. So what happens? This opposite party, antisocial, they forcibly came into the college premises and constructed shop room. Then this petitioner is the principal. She lodged a affair before the police. Then those opposite party to enter to the college lane filed a petition under 145 before the executive magistrate. In that case, we appeared party. What happens on the very day, the advocate for this not done. So, for that reason, we filed a witnesses. That has been rejected. That petition is under challenge.
311.
My Lord, that is Annexure 5 is the impugned order. That is dated 6/2/2024. That starts with page 15. And ground taken, Your Lordship, they have taken that this court does not feel it proper to recall the witness for cross-examination and retrial afresh, which would be much hardship to the first party. Considering the above facts, this court is of the view that the petition dated 2011-2023 is not sustainable.
Where is your application?
My Lord, that is Annexure 4, Your Lordship will see. That is application for recall, the order dated 9/5/2023. That starts with page 45.
You want to cross-examine PW1?
My Lord, PW1 and 2. Your Lordship may target it. And also I am ready to deposit some cost because the ground they have
What
taken.
is the stage now?
Stage, Your Lordship, trial has not yet been commenced. Only
Not commenced.
PW1 and 2 has been examined and it is still pending on that stage.
Yes, who is appearing?
It's a private.
Private property party. Your
Issue
Lordship.
notice, Lada.
My Lord.
Issue notice.
And one miscase, Your Lordship, I have filed that has not been found. That miscase number is Your Lordship will
It's
see.
all right. I am issuing notice.
My
Nothing great. Yes.
No, Your Lordship, my predicament is because that will commence for that reason. Suppose.
So what happens if 3, 4, 5, 6 is examined? 1, 2 cannot.
No, they have already closed their witnesses. Now.
And you said that nothing is. Why are you making that statement?
My Lord, my Lord.
That's why I asked.
So Your Lordship may.
It's the only initial stage.
My Lord, initial.
I will allow this application. Don't worry.
My Lord.
I will allow this. Yes.
33. May I pardon, my Lord? May I pardon, my Lord? One compromise matter, item 86. One petitioner, my Lord, the injured person is unable to work, and he is waiting below the court.
Item number?
86. 84.
He is injured by whom?
My injured means an accident. Met an accident.
Case of 2015, there are 3 active persons. All 3 came here, my Lord. But due to fracture in his leg, one of the petitioner would not be able to come
No.
here.
It's all right, no problem. No problem. Where is the informant?
Informant advocate is there or informant is also there?
88, na?
84.
84. Let us take up that.
307.
307.
87.
84 million.
Yes. 80, 84. Injury reports for me.
Injury
Report, they have given my injury report.
Simple.
How many injury report?
Annex of 2.
Huh?
They have given the injury report, page 14. Simple head injury, simple injury, sir.
Simple.
Mal.
Page 14, madam.
Right.
One of the actors there.
Who could not come? Deepak.
Deepak.
Is here, my lord, in the.
No, it's not right. No.
The High Court, my lord.
Nihar Das, Lipa. Nihar Das, Lipa. And
Yes, sir.
Basant Naik.
Basant Naik.
He is informant and victim.
Victim, my lord.
Both.
My lord.
At the instance of opposite party number 2,
Basant
FIR number 2 came to be reached against the petition. After the investigation of the FIR, the charge sheet was filed on Tuesday, for alleged offence under section 341/294/320/379/379/506/34. When at the stage of the trial, the petitioners have settled their issue. The injury report is on record. Annex 2 indicates that the injury sustained by the opposite party number 2 are simple in nature. What is the terms of settlement?
Madam?
What are the terms of settlement?
No, don't want to proceed. Because already resolved and we are living friendly lessons.
Both are same villagers of different political party.
Application against the petitioner are that on 9/8/2015. Petitioner and petitioners have assaulted the opposite party number 2 and took away gold chain from the opposite party number 2, and also gold chain taken away, gold chain and money. He gold chain and money which he was possession. The informant forwarded is that the opposite party tried to kill him. Phase 2 para 2. The parties have the petitioner number 1 and the petitioner number, all the petitioners shall I record that all of them are present. Why should I?
Pass of the petitioner number 1 is also with me.
The petitioners are present in the court. Petitioners and opposite party number 2 are present in the court. They are being represented by the respective counsel and identified by them. They've also filed the self-edited copies of their Aadhaar card, which are taken on record for establishing their identity. The parties have filed affidavit, joint affidavit. The opposite party number 2 has filed an affidavit dated 26/4/2024 in Australia, stating that he has settled the dispute to the petitioner on the intervention of the elders and well-wishers, and he is not willing to prosecute the petitioners anymore, rather prefer to remain as friends. Mr. Ragda appears for the state.
Visitor pastor record thao. As a visitor pastor, akorsin as manager lekhdel.
Ragda appears for the state and submits that although the charge sheet was filed under
All of them asked.
307 IPC apart from other offences, and the petitioners have been absconding in this case. However, since the parties have settled the dispute, and appearing before this court, there is no appearing this court. and the injury sustained by opposite party number 2 stated to be simple in nature, there is no legal impediment in quashing this FIR. Keeping in view Gyan Singh and Joshi, subjecting the petitioner to trial equitable exercise. Quash, how much you will pay? How many of you there? Pay to the complainant. How much? 3,000, 2,000 each.
1,000 each.
2,000.
My lord.
Okay.
My lord.
2,000 each to the informant. Where is the informant? And while the who is the informant? Basant Naik. Basant Naik ki 6,000 টাকা সেমান দেবে দেলা পর রিসিভ আনি ଆପଣ ଆପଣଙ୍କୁ 6,000 ଟଙ୍କା ଦେବେ ସେମାନେ ଠିକ ଅଛି ବର୍ତ୍ତମାନ ଦେବେ ଠିକ ଅଛି yes next 40 for compromise 40 yes yes
Lordship, between the two Sahi peoples in the Ganesh Bhasani, the dispute arose, and meantime in the village meeting that has been settled. My lord. And all are present. The two petitioners are absent.
Mr. Maharaja, who are absent?
6 and 7, your lordship. 6 and 7. 6 7 medical documents medical SCB admit ହେଇଛି
allegation
and madam yes yes
Rina Das
yes madam
yes ask
sitting down
Prabhakar Das Sibo Das Milan Das Silva Das Ayush Kanta Das, Anil Das,
Anil Das nahi 6-7 absent also
Tulu Swine,
7 absent
Prabhat Jena, absent.
Witness party number 2 FIR so came to be registered the petition. The allegation in the FIR is that on 25/9/2022 on the occasion of Lord Ganesh Bhashani at Projo Biharipur, petitioners have abused other lady members in obscene languages, casting aspersion on their caste and they also assaulted the opposite party. Therefore, the FIR was. Investigation is on, huh? The after investigation charge sheet.
No, charge sheet submitted. Cognizance has challenge.
Charge sheet has been filed.
Page 20 cognizance order is there.
23 and thereafter.
Cognizance has been taken. Page 20 is the cognizance order.
Court below has also taken cognizance of offense under section so. Page 20, yeah?
Yes.
Page. No, cognizance order.
Page 70, your lordship. 11/8/2023.
70.
Yes, your lordship. 70.
70. Under section so. At this stage, the parties have settled there. The petitioner number who all are present, barring petitioner
Except
number
6 and 7.
6
all
and
are
7. All the petitioners are present in the court. They are being represented by their respective counsel and identified by them. And opposite party number 2 is also present in the court, being represented by her counsel and identified by him and filed the other question. Where is the affidavit?
Yes, affidavit file, your lordship.
The opposite party number 2 has filed an affidavit dated 3/5/2024 stating that she has stating that she has petitioner on the intervention of the local intervention of the elders and the well-wishers in the locality. She has revived the relationship, friendly relationship with all the petitioners. Therefore, she doesn't want to prosecute the petitioners in the present case. Present case. Present case. Mr. Maharaja appears for the case and submits that the dispute is rising out of a small incident, and the parties belong to the same locality. Since they have settled their dispute and filed an affidavit before this court, there is no point. The subjecting the petitioner would be subjecting the petitioner to trial would be definitely a good exercise. Therefore, the case of the petitioner is squarely covered by the judgment of Gyan Singh and Procedural. Regarding head to the facts of the present case and the judgment of the Honorable Supreme Court, the petition deserves merit. Accordingly, the FIR shown was. And how much you will pay? 7 of you.
Poor people are
What poor?
Sahi
10
pila,
people.
sabu pila.
See the behavior. You don't have a minimum courtesy. You are abusing the women and all. You pay something. 1,000 each. 10,000 rupees pays to the lady.
ଦେଇପାରିବନି ଗରିବ ପିଲା ଗୁରା ଦେଖ ସାହି ପିଲା ସାହି ଗଣେଶ ପୂଜା ଗଣ୍ଡଗୋଳରେ
ଗଣେଶ ପୂଜା
ସାହି
5,000. No, 5,000 you pay. 5,000 to
yes sir.
All 10 of you give 5,000.
Minus.
Okay. 5,000 ଟଙ୍କା ଆପଣଙ୍କୁ ଦେବେ ସେ ଦେଲା ପରେ କହିଦିଅନ୍ତୁ। ବାହାରେ କୋର୍ଟ ବାହାରେ ଦେବେ ଆଜ କହିବେ କହିଲା ପରେ ଅର୍ଡର ବାହାରିବ। Give 5,000. You have abused here, all 10 of you. Some deterrent, yes. 29. Next.
Both parties are present, my lord. The matter is item 29, your lord.
29, okay. Come on, 29. 29 years. FIR 498A.
Yes, my lord.
Where is the FIR?
Yes, my lord. Page 11, my lord.
My lord, 30.
Don't make it so simple.
Yes, but my lord.
306, my lord, and 304B, my lord.
Adjourn beyond vacation. Why are you making such statement? It's a matrimonial issue. It is 302 case.
Charge sheet has already been submitted, my lord.
304B.
Yes, my lord.
Then?
And other offences like
Maybe 304B.
And there is no material so far.
It's not so easy a case. Don't make it so simple.
No, charge sheet also
somebody has died.
The case of suicidal. For that reason.
Whatever. That's
okay. I'll report
after vacation. Yes. Next.
Any day before vacation, your lordship fix it.
We'll see. We'll try to adjust. Yes.
33. May I please, your lordship. In this case, my lord, petitioner is the owner of the vehicle, my lord. The allegation is that he caused the accident, my lord. And the person who died, my lord, was the accident, my lord. He was a member of the bar. Though the FIR was registered, my lord, under section 279 and 304A, my lord.
Yes.
Yeah, both my lord sections are available. Till then, my lord, the police arrested and forwarded the petitioner to the magistrate, and a magistrate, my lord, remanded the
where is that? Remand.
That has been occurred, my lord, on 4th of this month, my lord.
You show me merely saying will not, available offense.
Day after yesterday, my lord, your lordship had this matter. Also, it directed to file the affidavit.
Yes. Where is that?
And I called upon the brother of the petitioner, my lord. He come today, my lord. He is present in the court and file affidavit, my lord. My lord, stay saying everything.
Give me. Give the affidavit. Just see the affidavit. Where have you said that?
ସେ କଣ ଓକିଲ ଇଏ ମାଗିଛନ୍ତି ଦେଇପାରୁନାହାନ୍ତି ଓକିଲର ଯେ ସେଠି ସେ ଡକ୍ୟୁମେଣ୍ଟ ଦେଇଦଉନି କୋର୍ଟ
Yes,
Yes.
what is this?
Yes. That's the appropriate order you will pass. Because
And forthwith, I'm releasing him.
Yes, yes, my lord.
it's a bailable offense.
Bailable offense, what is this?
Intentionally, yes,
I'll
my
call
lord.
for a report from the.
It did not justify.
Acceptable.
And it is stated, my
Petitioner
lord.
is an accused. Petitioner is an accused. In FIR number so and so, under section 79 and 304A. The allegation in the FIR is
बार संभव करी तुम छोड़ना.
the petitioner was driving a Swift Desire car bearing number OD 31 D4336 collided with the one motorcycle of the brother of the informant, Suraj Biswa, and who was taken to the hospital, and he succumbed to the injury. Therefore, the PS case number 99 of 2024 under section 379 oblique 304 capital A IPC has been registered against the petitioner. And consequently, the petitioner submits that despite both the cases are bailable in nature, the petitioner was apprehended by the police and produced before the court, and who was remanded to judicial custody. Although the proceedings of the court below are not placed on record, however, an affidavit is filed by the petitioner, brother of the petitioner, Mr. Boruna Deura, on 9/5/2023, inter alia, stating as under para 4. The brother of the petitioner categorically stated that the petitioner was produced before the court of SDGM Sambalpur on 5/5/2024 at 5 p.m. and he was remanded to judicial custody, and at present the petitioner is lodged in Sambalpur jail.
Yes.
Sambalpur jail. I'm failed to understand as to why the police has produced the accused, produced the petitioner before the court of SDGM, and in what circumstances the SDGM Sambalpur has remanded the petitioner to judicial custody in a case where the petitioner is involved for offences alleged to be under section 279 and 304 capital A, which are bailable in nature, taking into consideration the peculiar facts of the present case, I'm inclined to allow the application and direct the shall I direct the petitioner to be released forthwith, and apart from that, the SDGM Sambalpur is directed to submit a report as to why and under what circumstances he has remanded the petitioner to judicial custody. This is the matter on 14. And take the order and get him out. Take on record.
You also make quoted for 36 malad the service. When the offense is available in nature malad, it is duty of the court to grant him bail, and if he unable to furnish the bail bond, then only he is demanded custody, or otherwise personal bond.
Let him give the report. But you take the order and let him come out. I have granted the immediate release. Yes. 34.
My lord, item number 34, that is a Belgium matter, my lord.
Yes, tell me. When you got the bail?
My lord, by this now honorable court, I have been enlarged on a bail by the dated, my lord. on 27/5/2020.
Yes. NBW 25/9/2023, 500. Yes. Next.
35.
May I please issue Lordship, my lord, I am challenging the entire proceeding on the ground of compromise, my lord. The parties are today not able to come, my lord. Let it come, my lord, 13 or
You
14.
bring them.
13 or 14, no lordship.
Yes. Next.
Obliged.
36.
36.
Please, your lordship. My lord, it is a case of NI Act, my lord.
Yes.
My lord, the complainant has been examined as a CW1.
Who are you accused?
I'm accused.
Yes.
My lord, in his statement, my lord, that is a annexure 3.
Yes.
That is annexure 3. Kindly have a glance to the page 32, in
Yes.
which he has admittedly stated that I have no further amount to receive from the accused. And after the examination, he was discharged. Thereafter, the complainant filed another petition under section 311 CRPC to explain, clarify the statement.
Yes.
I have no further amount. And the learned JMFC Salepur has been allowed the petition. And I am.
What is wrong with it?
My lord.
What is wrong with it?
Yes, my lord. My lord, he has stated that I have no further amount. He has received the money. What is the
Whatever, but the court want to know what is the exact fact.
Yes, she has
The trial don't go by technicality.
No,
What is the trial? Trial is to ascertain the facts, and court wants to know
after he
what circumstances he has said that.
examination is the cross examination. Cross examination se कहूँ जे मु receive करी नहीं already. Then 311 petition to explain the statement was addressed in the cross examination.
Who has moved the application?
Application by the complainant after discharge. After discharge, he filed application, and subsequently, moreover, the learned trial court has been passed the order under annexure 1. In a same order, 2 petition was disposed of in the same order.
Now show me 311.
Yes, my lord.
What does it say?
Petition filed under section 311 on 4/3/2023, common order, and another petition which was filed before cross examination, that is to exhibit the some document by the complainant, that was filed on 8/9/2022. And Lord JMFC has passed the same order in same date, both the petitions. Dita petition no gotte order pass kale. That is the annexure 1.
Which is the second one?
My lord.
The second petition is?
Second petition is annexure 6, my lord. Annexure 6, page 38.
What was that?
That was it for exhibit the exhibit passbook. The complainant has not exhibited the passbook.
What is check amount?
Check amount 13 lakhs. I have already paid. He has admitted in his cross examination, because it is a fact that I have received 2 lakh taka cash rate on account pay, and already cash payment be he already.
Which part of the statement?
My lord.
Which part of the statement you are presenting?
Statement says cross examination se koi 32 page 32.
Which paragraph?
Paragraph 17. Because it is a fact before the.
It is a fact that after receiving the legal notice, the accused has
2 lakhs.
deposited
And in
cash of
para
2 lakhs in my
21.
account. Only 2 lakhs.
No, my lord. After 21 para. 21, I have no further amount to receive from the.
No.
He has received the on cash. Admittedly.
This 21 cannot be made in isolation. He has received only 2 lakhs. Whether it says that he has received
2 lakhs in the account. But he received other amount on cash.
Why are you reading in between?
Question was not asked because he was admitted that I have no further amount to receive from the accused. Admit
small line you are banging upon. Anyway, issue notice let us.
My lord. Yes.
Issue notice.
The date is fixed on 17 for further examination.
You move an application. You move an application.
Infrastructure say
No, you move on.
Infrastructure say of this application.
138, there is no question of stay because statute provides that 6 months. Statute provides 6 months.
Case.
You don't have a case. I am just exploring the possibility of settlement in the sense If he has taken the money, I'll confront him and.
Till
close.
death, till their appearance, stay na kindly.
If you notice, let confront the petitioner submits that he would move appropriate applications for seeking adjournment, owing to the fact that the matter is sub judice before this court. Yes, next.
Stay na lage 17
Next.
तारीख 17 तारीख डेट फिक्स रही My lord 17 तारीख डेट फिक्स है for
I have given,
examination
sir,
of the
I have
complaint.
given, sir, you move application. I have application for adjournment.
37.
I've recorded that. Don't worry. Yes.
So petition was filed challenging.
If at all.
The options are not in down to a case of 304 part 2. The 304 part 2
Where is the question of that investigation is going on? FIR is lodged on 302.
So each account is not gone to available, then probably granted. But each account offense down to 304 part 2. Then matter because only that.
No. See, FIR was lodged under 379, 304A. And you are saying that
for taking evidence, then only it can be correct. Because 302 is the number. So only one if the account details has not gone to a case of 304. He shall be released for
he shall be released for bail in the event if the case if he is not forwarded in the offense under section 379 on 304 part A, rather in any graver offense, rather in any other graver offense. That is better. Rather in any other graver offense. Yes. Yes, sir.
Yes. I'm challenging the order of
yes.
charge. That is at page 127. And the learned counsel for the accused persons had submitted that no witnesses have been stated about the involvement of any of the accused persons.
What are you challenging?
I'm challenging the charge, my lord.
Charge.
Order at page 126. The relevant case is 127.
Charge has been framed against you.
Yeah, yes, ma'am.
You have to file a revision.
No.
File a revision.
Revision is 482 also.
Revision is appropriate. Move an application, I'll convert it to revision.
It can be converted to revision.
When counsel for the petitioner submits that he would be moving appropriate application for converting the present petition to be revision petition in view of the fact that he has essayed the order dated 4/3/2024 whereby charges has been framed against the petitioner. He may do so within 2 days.
Yes, ma'am.
Within 2 days, it's the matter on 20th or 21st.
Yes, ma'am. 20th, ma'am. I will take my chance.
Yes.
Vacation.
38.
This matter, I pray for an adjournment. Let it come after vacation also.
Yes. Adjourn. Yes.
45. 45.
What about 39?
45 my lord.
39.
41 ଟା ମୁଁ ଆସିଗଲି.
39.
49. Hey,
39.
39.
Why are you jumping?
Lots of compromise.
May please, Lordship. Here, my lord, this is a matrimonial matter. Petitioner 1 is the husband, and other are the in-laws, and the opposite partner 2 is the wife. Who was stated that she has stated that he is the would-be wife of the petitioner number 1, and in the meantime, Lordship, she has already got married to another boy and blessed with a child. So notice
then why don't you settle?
So notice may be sent to the.
I'll send it,
Yes.
but
Yes.
if she is married somewhere else, she is not interested in you.
No, sir, there is a things, my lord. Unless the proceeding is going on, my lord, notice may be sent to the office matter to my lord.
Do you think that
Letter appear.
do you think that there would be a chance of
Yes,
settlement?
yes,
You
letter
come
appear,
forward.
later appear.
Huh?
Yes, ma'am. OP number 2.
Yes, Mr. Rahul, I'll pass the same order.
Yes, my lord.
Send it to mediation center.
Mediation
Notice
center
and,
is better, my
She
lord.
is already married.
Married and based on the child also.
Blessed with the child.
And staying
It is
or
better, my lord, to
staying
send
or
it to
in-laws
the
house.
mediation center.
Present in-laws house.
I'll send right now. The petitioner is an accused in FIR number so and so. The dispute is arising of a matrimonial dispute. Then counsel the petitioner submits that the opposite party number 2, who is the informant in the present case, has already married where divorce has already been granted.
No.
No.
While pending the case, my lord, while the dispute is pending, she got married.
Submits that during the pendency of the dispute subject, the opposite party number 2 has already married and blessed with a child as well. Therefore, there is all probability that the matter would be settled out of court. In view thereof, issue notice to the opposite party number 2, and matter in view thereof, the present matter is relegated to the High Court mediation cell. Where is the police station?
Well, that is Nayagarh. There is
Fatehgarh.
Fatehgarh, Bhapur JMSC.
Where is that? Fatehgarh?
Nayagarh district.
Nayagarh district.
Then Nayagarh district court, district mediation cell.
Yes.
Huh?
What I think, my lord,
problem
but
may
she
be
is staying at Banki.
if the
Kotak. Lady is staying at Banki
Then
Kotak.
High Court
better.
High Court.
ಅಂತ address ಅಂತ
Banki ରହୁଛି ତ ଏଠି ତା
yes ma'am.
ନୂଆ ହଜବେଣ୍ଡ ଆଡ୍ରେସ ଦେଇଛି।
ତ କଣ ଦେଖିଲ
Banki
High Court
Kotak Banki।
ନାଇଁ ବା ଇଏ High Court mediation
party also issue notice to opposite party number 2, returnable and also awaiting the returnable first reopening date video, awaiting the mediation. In the meantime, proceeding are on this state.
Yes.
Yes. 41.
May I please, your lordship?
Yes, Mr. You could reach before lunch.
Yes, my lord. I could reach, my lord. Because there I mentioned and got it done as the first case, my lord.
Yes.
My lord, here, 4 cases are, my lord, the FIRs have been lodged by 1 person. Against the accused persons are the same in all the 4 cases, my lord.
4 cases, 1 complainant, 4
same accused persons, my lord, and the cause of action is 1 and the same, my lord. My lord, here
41 to 44.
41 to 44, my lord. There are also 2 other accused persons. They had moved this Hon'Ble court in other 4 CRLMC applications. Their interim orders have been passed and they are pending before
in the same FIR.
Arising out of same affairs, my lord. And that is, my lord.
Have you checked it?
Yes. Similar order, issue notice and similar order, interim order also may be passed.
Tag
and maybe tagged to
with
all the cases.
Yes. This you could have mentioned in the morning.
File uda nathila to
you made our job so easy.
File uda nathila bahar kariye pun deri
41 to 44.
41 to 44 all same orders.
Notice same order kar do. Tag kar do sir.
45.
सबरी नोटिस हबो टैग करियो त ये किमती ऑर्डर अछि
भला
ठीक है yes
45 first
45 this matter has been settled between the victim and the accused petitioner, my lord.
Yes.
The victim has already reached the court and she is waiting for a pass.
2 o'clock. Yes, next.
2 o'clock.
Yes, next.
46.
Lordship, it's a matter relating to release a vehicle the JMFC has imposed a condition of rupees 1,45,000 toward the expenditure of cost of maintenance of cattle and indemnity bond of rupees 90,000. It has been covered by your lordship's judgment at annexed to your lordship, that is in CRLMC number 3539 or 23.
Yes. What have I said there?
Uh,
6,75,400 change ହେଇଛି 1,50,50,000 ଟଙ୍କା
yes.
ତାର ରେଷ୍ଟ ଟା indemnity bond ଦବ ଯୋଉଟା ଚିରୁଟା
These are fact to fact different.
No. PC Act.
You want modification of the condition.
Condition. Page 14.
What are the conditions?
Clause C. Clause C.
Yes. Clause
C.
C.
Okay. Some he shall pay
1,45,200 towards the cattle maintenance.
each to the Binapani so and so good towards the expenditure of cost regarding the maintenance of the cattle
Yes.
and which were kept in Jima till so and the petitioner shall submit a necessary receipt before this court in regard to the payment of so and so.
Yes.
And he is also filed the indemnity bond of 9,000.
Right.
Okay. These are the two conditions you want.
Yes.
There is. And what I have said in the judgment?
Judgment ରେ ଆପଣ ଖାଲି କମେଇ ଦେଇଛନ୍ତି cash ଟା ଟିକେ କମା ହେଇଛି 1,50,000 cash ରହିବ indemnity bond indemnity bond ଟା
ଏଇ କେସ୍ ରେ କେତେ ଥିଲା?
ଏଟା ଥିଲା 6 ଲକ୍ଷ
6 ଲକ୍ଷ କୁ 1 lakh.
1,50,000 percent.
Yes.
How much you will pay?
ଏଟା ହଉଛି
45.
at least
Half amount be callable.
75%.
75.
75%. Indemnity bond. The petitioner is agreed by the condition imposed by the court below while allowing the application for release of his vehicle involved in the offense. Therefore, he seeks modification of condition number
C and D.
C and D imposed by the court below by its order dated imposed by JMFC which court is this? JMFC Jasipur.
CMC
By its order dated 22/3/2024 in CMC number 2 of 2024. The conditions reads as under. Condition like the 14th, T&D.
Page 14.
He seeks the petition, counsel for the petitioner seeks modification of the state order, relying upon the order of this court dated 19/1/2024, passed in CRLMC number
29.
39 of 2024.
It is 29/1 of 24.
29, date 29/1/2024.
3539 of
24. Mr. Maharaja appears for the state and submits that applying the ratio, applying the petitioner is entitled to the benefit of the order of this court passed in CRLMC 3539 of 2023.
Yes.
Accordingly, the condition imposed by the court below by the order dated 22/3/2024 is modified in the following terms. Petitioner shall pay following terms.
Cash of rupees 75,000.
Petitioner shall pay deposit. Petitioner shall deposit a cash of rupees 75,000
Instead of
1,45,200 and she shall also file
the
rest amount. She should furnish a indemnity bond in regard to the rest of the amount. Apart from filing an indemnity bond of 90,000. Modified. Around.
75. Can it be 50,000 instead of 75,000?
Be happy. Be happy with this. Yes.
47.
May I please? But in this case, the petitioner, aged about 70 years, is assailing the order of rejection of the petition filed under section 311 for recalling of the witnesses, my lord.
Yes.
There are certain questions left which are vital and just decision of the case, your lordship has filed a petition under section 311. Your lordship may kindly come to page 12.
How do I know that these questions are left?
मतलब page 12 your lordship may kindly deposition copy. Kindly come to page 12 only.
Come to page 12, what answer it? How will I know?
Be that as it may be, I bow down your lordship, but page 12 your lordship.
Yes.
But from the perusal of the impugned order, it is telltale that there is no reasoning, nothing, no discussion about the petition, your lordship.
So see, small application disposal, you need reasoning and all, then the court can't function like this. You show me, do you have that statement with you?
Well, those deposition copies, Xerox copy would I go achi, my lord. I will supply another copy, my lord.
Xerox copy will also do, don't worry.
But today only I received this Xerox copy.
Just examine whether whatever you are saying is correct or not.
My lord.
Whether these questions are put to the witness or not.
My lord.
And see, in so far as in para 4 of your application,
My lord.
you have proposed the question.
This question.
Whether these questions were put to, or what is the relevancy? That has to be examined.
My
BW2. He seeks recall of how many witnesses?
My lord,
3, 4, 5, 6, the entire lot.
My lord,
You want a retrial or what?
My lord, 2, 3, 4, 5, only pertinent questions, my lord.
What is pertinent? You have to examine them.
My
See, so many witnesses you want to recall.
My lord.
Then you want to have a retrial virtually.
Well,
I'll put it on 20th, just examine.
My lord.
And give a copy to
My
you.
lord, my lord. I'm giving it.
Just
that I
see,
was.
and fair enough to tell the court which
will.
witness you really want.
My lord, my lord.
Not that lot, the entire.
My lord, I bow.
And 35, 33, 5 is there. Victim is ruled out. Victim is ruled out. Apart from victim, who else you want? Yes. I'll straight away allow.
On 20th.
20th.
20th. Obliged.
Yes. 48.
May I please your lordship, I am in VC, my lord.
Yes.
My lord, here, the offence alleged is 20B Roman 2C read with section 25 and 29 of the NDPS Act. The vehicle of the present petitioner was involved in transportation of the contraband. That is not in dispute. My lord, I was not named in the FIR. On the statement of the driver, charge sheet has been filed and cognizance has been taken. My lord, I am relying upon Tofan Singh judgment and 2 other judgments. My associate is there, he will hand over. My lord, here there is no iota of material that my presence was there, and it is a commercial vehicle. It's a taxi registered vehicle. The driver had taken away and he transported ganja. Because I am the registered owner, as per the statement of the driver, I have been implicated and given a final charge sheet and cognizance has been taken. There is nothing against me. Your lordship will see the affair. I have not completed, Mr. Maharaj. Please wait. I have not completed. I have not completed, sir.
No. At the 1 minute. 1 minute. At the stage of cognizance, do you need me to ascertain all these facts?
My lord, I will prima facie.
What was your complicity?
My lord, I will prima facie show from the document. FIR and charge sheet, nothing else. Now charge sheet is there, my lord. There is nothing to more investigate. Charge sheet is there. Your lordship may kindly turn to page 16.
16.
Yes, madam.
16. Okay.
16. The driver Kartik Sabara was there in the vehicle. FIR was registered in his name. Thereafter, on his statement, the final charge sheet is being filed against me. My lord, I have been added as accused number 1 at page 26. I don't say, my lord, that I will not be there. But question is that what is my role in this case? My role is not there. I was neither present in the vehicle, nor I was involved in the transportation, nor I was carrying the contraband ganja. The initially FIR is against one Kartik Sabar. On his statement...
Where are the statement in 161? Show me.
Yes.
Where do you have the statement of witnesses under 161?
My lord, yes. My lord, may kindly see, there are no statements, only charge sheet is given, my lord. I have annexed the entire certified copy of the charge sheet. No statement is there.
No, statement would be there. Yes. You might not
My
have
lord, may
got that
kindly see
statement.
the charge sheet. Except that implication and the charge sheet report at page 34, nothing is there. Nothing has been provided to me because I've got the entire certified copy. And the statement.
Yes. Yes.
It's a case of 687 kg, 100 gram of ganja was transported in the vehicle of the petitioner. And the petitioner pleads that he does not know the contraband or transport in his vehicle. But that cannot be tested in this application in the present situation. Number one. Number two, anticipated bail was rejected by this honorable court, observing all, and that certificate has not been given in this application.
Where is that order?
The reason,
Where is that order?
my lord, ABLPL number 215 of 2015 of 2023,
Where is that order?
rejected on 6/3/2023.
Get that order.
Second, 2015. 2015.
I'll hear it on 20th. 20th. Get that order. Huh? Get that order and put it. 20th. Yes, next. Next.
Yes, ma'am.
49. 49. 1 minute. Another 5 minutes.
May I please your lordship? Lordship, the present petitioner in this petition challenge the order dated 8/4/24 and the consequently register FIR, lordship.
21st for this year. Other matter. 21st. 20 20 रे बहुत दिन बहुत 21 रे कर दा रीच करियो ना करियो yes.
The genesis is that one CC case has been filed with a prayer to direct the IAC to investigate the case under section 156(3). The magistrate by order dated 8/4/24 by an on-speaking order dated direct the IAC to register an case within 24 hours. Consequently, this case has been registered. Lordship, for a moment, kindly see page number 20. In para 6, whether any information was given at the police station, if so, the action taken thereon.
No.
No information has been given. As per the ruling of Honorable Apex Court in Priyanka Srivastav case, 154(1).
Yes.
Priyanka Srivastav case is not applicable to this.
That is affidavit.
That is the affidavit. Number one. Number two, there are three options. When affair has not been registered by the concerned PA, the information is to be given to the higher officer.
155.
Yes, number one. Number two, then either you will prefer a complaint. Number three, if no information is given, independently a complaint case can be filed. That is the intention of the legislation. That does not mean that if he has not reported the higher authority, the complaint petition is not made. That is one thing. And I don't know, my lord, a junior counsel, I should not say so. It's a new practitioner. Why you are concealing all this aspect while your application has been rejected by this honorable court? Thrice.
Which
APL number 4494.
Note down.
No. Lordship, may I submit on that aspect?
Do you know that this?
I know that. I have in the certificate, I have given that the no application is present in this court in present form. There was anticipatory bail. Lordship, and that anticipatory bail has been allowed. Yesterday that has been allowed, not rejected. There are three petitioners.
Try to understand.
Lordship.
We are not saying anything against you.
Sir, Lordship.
The idea of this declaration is the court should know what are the proceedings you have initiated
Lordship.
in this court.
Lordship.
So you should have told all these things.
Lordship.
So henceforth, when you are filing the petition, make sure that everything is disclosed.
Lordship.
That is what it says.
My
You are
apology.
staying
My
in the right
apology.
spirit.
Lordship.
If they are the
So
senior,
far,
you should learn.
Lordship, let me submit only one paragraph from the Priyanka Srivastav case.
Yes. What is this?
We have already indicated that there has to be prior application. Again, prior application under 154(1) and 154(3) while filing a petition under section 156(3). There has to prior application.
Right.
In this case, the complainant herself is declaring that he has not filed any application. Second thing, Lordship, both the experts should be clearly spelled out in the application and necessary document to that effect shall be filed. In the entire complaint case, nowhere he has ever that he has approached the police, then to the SP, then he come before the court.
Petitioner is seeking quashing up for the FIR, quashing up for the FIR number so and so, which which has been registered pursuant to the order of the which court?
SDJM's Titlagarh.
Under section 156(3) CRPC. And Leonard, what is your name, sir?
Ghanshyam Banji.
Ghanshyam Banji.
Banji. Banji.
Ghanshyam
Banji.
Banji. Let account of the petitioner submits that perusal of the complaint under 156(3) CRPC indicates that the petitioner, the opposite party number 2, has herself given a declaration that she has not approached the police before filing the present petition. Therefore, his case is directly covered by the judgment of
Priyanka
Srivastava, citation so and so. Priyanka Srivastava. Issue notice to opposite party number 2, returnable on sanction. Okay.
Lordship, I have filed an IA.
The petitioner submits that he would move appropriate application before the court below, seeking an adjournment owing to the fact that the matter is of judice before this court.
In the meantime, I may not be protected then.
You got the anticipatory bail, as you told. There is no threat of arrest. And in the
there are
complaint case will be adjourned.
3 petitioners in this case. 2 has been granted bail. 1 was
The other 2, you file another petition there for the date on the ground of parity, they will also get. And you have one more brief for you. Ready? Okay.
Let's see. Oh, like.
Yep, 45. Item 45. Okay. Yes, 45.
Now the parties involved in the criminal proceeding, they have settled the dispute outside the court, and the victim, she does not want to proceed with the case because of her future.
Where is the victim?
She's a victim. She's a BTech student, and
Political case, 28%. 28%.
28%. 28% and you are appearing.
So I will pay from my pocket. That's why some less.
You pay from pocket. Pocket 28%. 10,000 to bar. 10,000 rupees. Bar. 500 भी बोलूँ यहाँ, don't count it like that.
Count कर दिल.
10,000 rupees to bar association. Yes.
To High Court bar.
High Court bar. Yes.
Right, pardon. If possible, in course of the day, the election is on Mondays. That's why.
The order.
If possible.
No, you want the order to be cited.
Urgent certificate.
फटाफट कर दो सर्टिफिकेट कॉपी.
Oh, blessed.
आज ही दे दो. ठीक है.
53.
सरला पर फास्ट टाइप. Yes. Bail जब ना. 53 for.
Please, your lordship, madam.
Yes.
Madam.
When you got the bail?
Madam, he has not bail. Matter is compromised, my lord.
I am the informant of opposite party number 2.
Madam, matter is compromised, and so, except 3 persons, all are released on bail.
So bail,
So I think
release on bail. 18 12 23 500.
नहीं 18/23 नहीं 18/23 एनबीडब्ल्यू इश्यू है जी
हाँ
कंप्रोमाइज है जी ମାନେ compromise ହେଇଯାଇଛି ଏଇଟା। ନାଇଁ ତାଙ୍କର compromise petition ଦିଆ ହେଇଛି district court ରେ and lower court JMFC
That is
ପାଖରେ।
what I am saying. I am watching NBW. Go and move there.
ଆସନ୍ତୁ ସେ ଏଇଠି ଏଇଠି।
NBW cancel କରୁଛି ଯାଆନ୍ତୁ allow କରୁଛି 1000 rupees.
ନାଇଁ NBW pass
Sir,
କରିବା।
I am quashing the NBW. Please go to that court below and appear and you want to settle it. No, nobody stops it. Pay 1000 rupees to the bar. ठीक है? Okay.
54.
May I please your lordship? The petitioner is on bail by the PLA number 8460 of 2017.
23. 500. Cancel. Cancel.
Obliged.
56.
Belgium matter. He was on bail 30th 11/2010 and NBW is on 7/9/2022.
22.
Yes.
500. Yes.
57.
May I please just? Here, my lord, I am challenging the order of NBW, my lord. That is, my lord, this is not a Belgium matter, my lord. The order dated 25/8 to. You also can see Annex 2, page 22, my lord. I am challenging the order of NBW issued against the present petitioner, my lord, on 25/8 to.
You are not on bail.
No, my lord. This is, I am challenging only NBW, my lord. We are not bail, my lord. I am not on bail, my lord.
Absconder. Petitioner is an accused in FIR note also. Is shown as an absconder. NBW issued on 25/8/15. 1000. Yes.
58.
30th June they told.
May I please your lordship? This is a Belgium matter. Petitioner released on bail 13/5/2019 and NBW was issued on 11/10/2023.
500.
59.
Please issue lordship, my lord, Belgium matter. NBW was issued on 20/3/2024, my lord, and he is on bail, my lord, 22/11/2017 in ABLP number 17682 of 2017.
500. Yes.
60.
60, my lord, on behalf of Mr. Sahu, my lord, I may be permitted, my lord, Belgium matter. NBW dated, my lord, 25/3/2022, my lord.
But you have to pay now.
I have to pay. Your lordship. That is in installment.
In the execution proceeding initiated by opposite party number 2, the warrant has been issued against the petitioner for having failed to pay the arrears of maintenance to the tune of
1,95,000.
1,97,000. Then cause for the petitioner to submit that he would be paying the arrears of maintenance to the opposite party on or before 30th of June.
Within installment, your lordship.
On installment basis.
On equal installments.
He may appear before the court and move such application. If move up such application, if that application is moved, the same shall be considered on its merit. On or before appear. Yes. Yes. No cost, huh? Private matter.
67.
67 data.
68.
68.
My lord, bail was granted on 26th March 2009 and NBW on 10th of October 23.
23. Okay, 500.
69.
69, your lordship. Bail was 10/1/2022 and NBW is 22nd March 2024.
500. Yes.
70.
My lord, bail was granted on 30/5/2017 and NBW has been issued on 23/3/23.
Got it. It's 500.
71.
My lord, bail was granted on 5/9/2014, so 11/9/2014, and NBW has been issued on 10/1/2024.
NBW
10/1/2024. my lord.
24, 10/1, 2025.
72.
72, my lords, bail on 29/4/2005, NBW on 29/9/2021.
21. 500.
73.
May be permitted to, my lord. My lord, there is a probably mistake, my lord, 41, 42, 43, 44. ସେଥିରେ ହଜୁର କରିଲେ ଅର୍ଡର ସେ ଯୋଉ କେସରେ ଯାହା ଅର୍ଡର ହେଇଛି ସେଟା ରହିବ ନୋଟିସ ହବ ଓପି ନମ୍ବର 2 କୁ ସେଟା ବୋଧେ ଭୁଲରେ ମିସପ୍ଲେସ ହେଇଯାଇଛି ଅର୍ଡର କପିଟା ସେ ସେମ ଅର୍ଡର ହବ ଖାଲି ପିଏସ୍ କେସ୍ ନମ୍ବର ଗୁଡାକ ଚେଞ୍ଜ ହେଇଯିବ ସେଥିରେ ସବୁ
Now you understood na? Confusion nahi na? Any confusion is there? Ask him. If any confusion, he'll ask. Yes.
My lord, 73.
No, interim order interim orders are there.
Interim orders in other cases are there. Other जो चारिटा केस फाइल ହେଇଛି ସେଥିରେ interim order ଗୁଡାକ ହେଇଛି ଏଗୁଡାକ ତା ସାଙ୍ଗରେ ଟ୍ୟାଗ ହେଇକି ଆସିବ ନୋଟିସ ହବ ଖାଲି ଓପି ନମ୍ବର 2 ଆଉ interim order ଟା whatever is there in those cases that will be
So interim order will also be there, no?
interim order ଯାହା ଅଛି ସେ ହବ.
Yes.
My lord, 73, may I please, my lords?
Yes, sir.
My lords, here the offences are under section 20B2C, 25, 28, and 29 of NDPS Act. My lords, the petitioner has been arrested after 2 months of the alleged occurrence.
Bail application.
My lords, this is an bail application.
23. Okay. Yes.
My lords, after 2 months of the alleged occurrence, the petitioner has been arrested on the basis of co-accused statement and on from
What is the recovery?
My lords, the recovery is 21 kg 100 grams.
But antecedent is there.
But antecedent is there. Your
Similar
lord.
How many?
Only one
5
similar
antecedent, my lord.
5 other.
5 antecedent.
5 and
One is
Your lordship
similar
may-
nature.
Your lordship may kindly turn to
One
page
is similar
22.
nature, another 4 are
Rejection order,
What
page
is it?
22.
Hmm.
My lords, fifth line from the bottom, my lords. That is 2ACC number 13 of 23. That is one similar antecedent. And the next page, if your lordship sees, there are 5 other antecedent, my lords. One is of 2006, 2005, 60.
What is your profession?
My lords,
Crime is your profession or what?
my lords, in stringent condition, but the similar condition, similar offense, only one.
Mr.
Yes, in-
Ragada.
NCB.
NGB, yes, NGB, you are ready.
In
What to do?
stringent condition, my lords.
Condition?
But,
Where shall he appear?
in view of
Where shall he appear?
to the NCB, my lord. Office of NCB, my lord.
Where?
Bhubaneswar. Bhubaneswar.
The accused stays where?
My lords, the
Fulwani. Probably.
Bhubaneswar.
Fulwani, because he involved in another case,
My lord,
Fulwani.
Kandamad.
He belongs to
He-
Fulwani area.
Village
And
Baliapada.
his antecedent also relates to Fulwani. Another NDPS.
IIC Fulwani police station. It will appear.
It is a NCB case, my lord.
NCB.
Bhubaneswar,
He has to appear before the court.
every time he can't come. no? Let him go and appear. before the police.
My lords, my lords.
And every month before NCB and every week before
Local PS is Pochapada, my lords. My lords.
condition every month before the NCB Bhubaneswar and every week the IIC Gochapada.
My lords.
Gochapada PS. Gochapada for 6 months. That's it, everything is fine?
Yes.
For 6 months.
My lords.
My name kindly be SB.
Obliged.
68 right? 68 date देखो item 68.
There are 3 petitioners. Petitioner number 1 is on bail 26/3/2009 and petitioner number 2 and 3 are 19/1/2012 and NBW is 10/10/2023.
74.
My lord, I am GC from Dhenkanal.
इसी bail तक ही ना समझ लो कोई किसी ने granted will लिख दो for particularly. Yes.
My lord,
74.
from Dhenkanal. BC from Dhenkanal, my lord. In this case, the accused petitioner is languished in jail custody for more than 3 months for the offence under section 457, 458, 395, and 397 of IPC, Your Honor. The brief case is that on 16/3/2015, some unknown culprits forcibly entered at 12 midnight in the country.
Yes, Mr. Arora.
So, for co-accused concerned, it was granted bail. This is the order, my lord.
Court
So, order pass and subject verification of antecedent. Only antecedent. Same order subject to verification of antecedent.
only antecedent भी जाइए bail पे.
हाँ, same question. Hello. Same order.
My lord.
Yes.
My lord.
Yes.
Okay, Your Honor.
76.
75 sir laga.
75.
May I please, my lordship, I mean, BC item number
Arjun.
75.
76.
Yes, my lord. Lordship, the alleged offences are under section 419, 420, 467, 68, and 34 of IPC with 66D of the IT Act, pertaining to some credit card fraud, wherein the co-accused person has already been released on bail by a lordship on dated 1st of March by BL appeal number 586 of 2024.
All the
my lord.
accused persons. Thereafter, other accused persons are granted bail. Fake, my lord, the credit card. Fake credit card. That case, my lord. Same condition.
ସବୁ ବେଲ୍ ଗୁଡାକ ଯୋଉ ଅର୍ଡର ଗୁଡାକ କାହିଁକି?
See, ଗୋଟେ number
586, my lord.
Where are the other accused persons got bail? Where are the
That is the BL appeal number, my lord, 586 of 2024.
one accused, thereafter other co-accused persons granted
other
bail.
accused persons number, bail number?
I don't have the other numbers, I have only that 586, my lord,
586
of 2024.
ଦେଖିଦେବ other accused person ମାନଙ୍କର ବୁଝି କରିଦେବ ଠିକ ଅଛି.
Grateful, my lord.
77.
May plus one. Offense under section 20B2C. 20B2C, my lord. Earlier bail application of the petitioner was disposed of by your lordship, granting liberty to move afresh before the law and trial court. Under annexure 2, page 20, I have annexed the order, my lord. In this case, custody since 10/6/2023, contraband ganja 516 kg has been seized, and the page 11 is the FIR, my lord. Can have a glance. That was seized, my lord, in front of the house of one of the co-accused, and allegations has been made that at that time the petitioner was there. In the mean,
This is CD call for on 7/5, my lord. But
I'm submitting one thing, my lord.
can take up,
meantime-
my lord, after my lord vacation, my lord. As because my lord, 516 grams ganja, otherwise, my lord, on 20th.
I know I have filed an IA in the meantime for the illness of the wife of the petitioner. That is a 5/11 of 2024. That is on
20th, I think.
20th as well.
on the IA, my lord. Instruction may be short.
Married, there is no such.
As to instruction,
Married, my lord, it will be rejected, my lord.
In the meantime, also, my lord.
Instructions on that application also.
So, for IA also, I will take instruction, my lord.
In the meantime, my lord, though my lord, the charge sheet in the case has been submitted, the C report till date has not been submitted. And your lordship, taking note of that fact, granted liberty to move before the law and trial court again. I moved and that has been rejected.
Withdrawn of first.
No, lekhai.
C report is not there?
Not there.
Well,
And I have
for that, case that not available.
22.
instruction may be short for my lord. So in the IA, my lord, lordship may pass order. On the IA,
I have said that.
I will take instruction on that.
Yes.
my lord, pass order to that.
He has already been called. On IA, Mr. Goda will seek instruction. Yes.
78.
70?
May I please, your lordship? The vacation.
Yes.
Mr. Sahu is not here. Can be taken up after vacation.
Urgent. Yes.
79.
Your lordship, for item 78, I'm for the petitioner, your lordship.
I'm for the opposite party, actually.
What do you want, 78?
But I was seeking for cancellation of bail, your lordship. The
Cancellation bill can be heard. Yes.
After vacation.
Next.
79.
79?
79.
Non-APS. 79. Modification of condition imposed by trial court. Urgent. Which is here.
80.
It may I please be your lordship? May I please be? I'm on Rishi Hon'Ble.
Yes.
My lord, 80 as per defect number 3, as in today it has been removed. The defect number 3, today it has been removed, my lord. So your lordship may take this matter next week.
Please the matter. Please the matter. Next.
81.
Please, your lordship, no, notice to opposite by 2 is unserved. Please kindly give me 2 week time, then we can file 81. Rest.
Notice on opposite party number
Rest
2
accusation.
remain unsought. Then account for defense seeks time to take fresh steps for service of notice on respondent. Reject. Yes.
Publish.
82.
82 man urgent.
82 not present.
82 not press.
82 not press.
83.
83.
Modification order, my lord.
Modification.
But case urgent to my lord 8/7/2024.
Modification by whom?
Petitioner, my lord.
Urgent already urgent. 87. List the application along with the main. Yes.
85.
Yes.
Defect, there are defects, my lord.
By way of last and final opportunity, 1 week time is granted to the petitioner to cure the defect. In the event the defect is not cured, the change can be dismissed without
86.
This is complete nonsense, my lord. Defects are there, same matter.
87.
It is not also defect are there. Only time to
don't cure within 1 week, then
this one.
88.
Okay.
Defect, my lord. No defect. Defect one defect is there, my lord. But in fact, my lord, his bail application rejected that has not been mentioned in the.
There will be.
No, my lord.
58 ago. Because point by the link from not sure, even the earlier proceeding initiated by the petitioner, available number of I-Pin for it, particular also earlier proceeding initiated by the petitioner, and for that's what not been. 1 week time granted. Of the defects.
Limited prayer. I am challenging the order of convenience. So, actually, grant will do points of the time of convenience.
Reserving the right to raise all the points, what we spoke below, at the time of living our child.
41.
When it is not done, not in this case, that petitioner challenge watching the FIR and also complaint is arising out of the FIR lot. Petitioner is the bank official, and there is proceeding under Circumstances Act recovery of the property of the defendant, my lord, OP number 2, and thereby there was a decree passed from the DRT court, my lord. By virtue of that decree, they have went under the recovery of the property and suppressing those facts. The defendant, the opposite party number 2, has filed a complaint case before the SDGM court, and thereby an FIR has been registered against the bank officials for proceedings to recover the property, my lord, not suppressing the entire fact, my lord.
The the petition submits that the opposite party number 2 had a way loan From which bank?
My lord, IDBI Bank.
IDBI Bank. And his account become NPA. Therefore, surface-side proceedings were initiated by the bank.
My lord.
The petitioner being the Deputy General Manager
My lord.
of NPA Management Department.
Well.
He took steps under law for recovery of the due amount from the opposite party number 2.
Well.
Out of vengeance, the opposite party number 2, by concealing all these material facts, have filed the FIR against the petitioner.
Well.
The opposite party number 2, Mr. Rahul, accept notice. What are the offences here?
My lord, the offences are 403, 406,
What is alleged against you?
Against my lord, these are the alleged, my lord, FIR is under this 403, 406, 418.
Section, forget about section. What are the?
They allege that in connivance with the, I was not there at that point of time, but they allege that in connivance with the one of the partner of the firm, I have withdrawn money.
What are bank transaction?
My lord, bank transaction.
Which notice to opposite party number 2, written rules also. What is this case?
Lord, it's under investigation.
Investigation.
My lord, I have filed a miscase.
Investigation, no, I can't say. I can't say the investigation. I have issued notice because the bank thing, let us see what can be done.
My lord.
Because you are a bank officer.
My lord, and
you
also
protected, therefore I am issuing notice.
My lord.
And better you go to the police and tell all these things.
My lord, already we have submitted. I think probably it will
I
come.
simply issue notice, let us see. Let him stop.
My lord, no course of action against.
I can't give that in the foreign.
As your lordship obliges.
Who will take action? The police also knows it, the bank transaction.
My lord, there is a decree also, decree of the DRT court.
Tell all these things. I think police will understand to give it.
Probably he's an influential person, my lord, so.
Pendency of this proceeding shall not preclude the petitioner to submit all documents before the investigating officer, and the investigating officer shall consider the documents to be supplied to be furnished by the petitioner. Petitioner before filing the report under section 1.
My lord, item 98 and 99, my lord, are 3 bank officers. Against them they have filed.
Same order.
My lord, obliged. 98 and 99.
Manager.
So 98 and 99.
You give all documents to the police.
My lord, we have already supplied the entire what
I have recorded it.
My lord, my lord. Let the whatever investigation your lordship may come and your lordship will.
92. Yes, madam.
Beg your pardon, my lord, 79 and I was against another court. And
What 79? 79 is over.
it is a prisoner's petition,
79 is over. What?
my lord.
Huh?
Nobody approved. My lord, 79 was,
Record is evidence. Record. Yes, next.
my lord, kindly taken over this modification, small modification. His bail was allowed by the court below, but he is in custody because of his poorness.
80?
79, Lord, sir.
79.
Kindly be taken.
You should be here.
No,
madam.
madam.
See,
Forty ଯାଇଥିଲି ଟିକେ ମୁଁ
present. How many matters? Somebody is in custody.
Yes, my lord.
79. Okay. Tell me what are the conditions?
Condition is 50,000 to solvent surety.
Where is that condition to me?
My lord, at Annexure 3, my lord. And
Please.
his prisoner's petition is also annexure.
79, na?
Yes, my lord.
79.
9.
Devasith Rao.
Yes, sir.
Here. Where is the condition to me?
Last page.
50,000, my lord, no condition, but condition not, he is not coming for modification of condition. But while releasing the bail, the non-court below directed to furnish bail bond of 50,000 and with its 2 solvent surety.
That is to be.
Sir, that is covered under 440.
My
Bail bond of 50,000.
My lord,
Bail bond of cash.
Page
Bail
16,
bond.
lord, kindly see, he is in custody. This is a legal entry. he is in custody after this order, he is unable to.
ଆଜି ଏକ ବର୍ଷ ହେଇଯିବ ଦିନ ହେଇଯିବ ଯାଜପୁର ଉପକାର ମତେ ମାନେ ଅଦାଲତ ବେଲ ଦେଇଛନ୍ତି କିନ୍ତୁ କେସରେ ବେଲ ପାଇଁ 50,000 ଟଙ୍କା ସିକ୍ୟୁରିଟି ମନି ମାଗି ନାହାନ୍ତି କିଏ ଭୁଲ ଦେଇଛନ୍ତି ମନି ମାଗି ନାହାନ୍ତି
ସେ bond ରେ
ମନି ଲିଖିଛି
Section 440.
50,000 ସିକ୍ୟୁରିଟି ମନି ଲିଖିଛି
ଯାଇପାରୁନି ସେ କହୁଛି ମତେ କ୍ଲିୟର ବଣ୍ଡ ରେ ଦିଅନ୍ତୁ।
ନା ସେ ଭୁଲ ତାକୁ ଓକିଲ ତାକୁ ଭୁଲ ଇଣ୍ଟରପ୍ରେଟ କରିଛନ୍ତି ସିକ୍ୟୁରିଟି ମନି କହିଛନ୍ତି ନାହିଁ ଦେଖୁନ ସିକ୍ୟୁରିଟି ମନି ମାଗିବା
ସେ ଆନାଲିସିସ୍ କରିଦିଅନ୍ତୁ
I'll clarify.
simply
Where is that condition? When the petitioner is furnishing bail bond of 50,000 rupees. So with the two chiefs,
my lord, that is the
let us say intermediate 50,000 cash.
petitioner has filed the present petition under section 439(2) of CRPC seeking modification of the bail condition imposed by the court of which court by the additional district sessions in Jajpur while enlarging the petitioner by the petitioner on bail by the order dated 25/9/2023. The bail, when counsel the petition submits that due to the onerous conditions imposed against him, he could not be released on bail. The condition imposed by the court below the reads as let the see the petitioner shall be released on bail by furnishing bail bond of rupees 50,000 with the two solvent surety each for the like amount. Solvent surety कोई ना 35,000.
ନାଇଁ ସେ ଏଠି election ରେ
Solvent surety କୋଉଠି ଆଣିବେ?
ପ୍ରିଜନର ପିଟିସନ ଦେଇଛି ସେଥିରେ ମୋ କେସ୍ ବେଲ ପାଇଁ 50,000 ଟଙ୍କା ସିକ୍ୟୁରିଟି ମନି ତା ଦୁଇଟି ବେଲ ରଖ
Solvent surety कोई 85,000. Solvent surety
clear bond
for the like amount to the satisfaction of the executive judge. He seeks modification of the same. On what ground? What is
cause ये कर पाएंगे
jail custody
16 नंबर पेज 16
फोन तो लिखित फोन
देवाशिष राउत एक वर्ष 23 दिन ହେଇଯିବ ଯାଜପୁର କାରାଗାର ଭିତରେ ଦିନ ବନ୍ଦୀ ଭାବେ ରହି ଆସୁଛି ମୋତେ ମାନବ ଦତ୍ତ ବେଲ ଦେଇଛନ୍ତି କିନ୍ତୁ ମୋ କେସରେ ବେଲ ପାଇଁ 50,000 ଟଙ୍କା ସିକ୍ୟୁରିଟି ମନି ତଥା 2 ଗୋଟି ବେଲ ରଖିଛନ୍ତି ମୋର ଆର୍ଥିକ ପରିସ୍ଥିତି ବହୁତ ଖରାପ ଥିବାରୁ ମୁଁ ବେଲରେ ଯାଇପାରୁନାହିଁ
due to the financial condition, the petitioner could not furnish, could not satisfy the condition imposed by the court. Therefore, the taking the position in the aforementioned, the bail condition is modified, and the petitioner is directed to be released on bail, furnishing bail bond up to 10,000. 5,000 crore. Then I think in jail 5,000. Huh? Yes, 5,000.
Yes, he has misappropriated of rupees 74,000 some hours.
Money would have come out. Let's see, 5,000 and 1 security of life. Yes. Yes. 93. Defect is level can you? No defect 1 week.
After vacation, after vacation,
yes. 94. 94. Same. None appears. Defect not pure. 95. 95. Same.
96. In this case, there is defect that a particular copy of the order has not been filed. But I have filed that in the criminal revision case. It will take some time.
What is the matter you tell me?
My lord, time. This is
defect pointed out by the registry.
My lord, kindly get the page 38.
38. Yes. Yes. Cognizance order.
My lord,
Cognizance.
cognizance, yes, my lord.
Yes. I commend this 424 What is wrong in it?
No, my lord, kindly, I am submitting my lord. On 21 March 23, the law and court below examined 5 witnesses. 5 witnesses. He specifically mentioned that PW2, PW3, PW4, PW5, and PW6. Yes. Examined. But my lord, come to the page number 39. He again examined those witnesses at separate number, giving number PW4 to PW5, PW5 to PW6. My lord, I am reading that. Page number, my lord, page number 8.
What is the big deal about it?
No, my lord, so it is one aspect. I am telling the fact of the case.
That aspect will leave it.
My lord. My lord,
It may be repeated numbering.
No, that is
not prejudicial.
no, my lord, that is not the case. That is one aspect. The case is that
You first talk about the best one.
my lord, my lord,
Start with the worst.
no, my lord, that's what
That's the
I
worst.
was waiting. My lord, come to page number 11.
11. Yes, tell me.
In the year of 2018, there was the allegation was that I took 30,000 each from the shopkeepers.
From 35 different vegetable
Vegetable. Totally false because those those ପରିବା ବିକାରୀ ସେମାନେ ସରକାରଙ୍କର ଯୋଉ ଦେଇଛି ଏଣ୍ଡୋମେଣ୍ଟ କମିଶନରଙ୍କର ଯୋଉ ଜାଗା ସେଇ ଜାଗାରେ ପରିବା ବେପାର କରୁଛନ୍ତି ସେଇ ଜାଗାଟାକୁ ପରିବା ବେପାର କରିକି ନୋଟାରାଇଜ ଏଗ୍ରିମେଣ୍ଟରେ ଜାଗାକୁ ବି ବିକ୍ରି କରିଦେଇଛନ୍ତି ସେଇ ଜାଗାଟା ଯେତେବେଳେ ମୁଁ I am an advocate of the Odisha High Court. When I got that information that vehicle land is being sold, I immediately approached my lord. My lord directed.
You file a PA.
Yes, no petition that was a division mention matter. Direction.
You file in the
Yes, my lord. Specifically. Thereafter, my lord, the land was 21 acres of the government land, of the deity land. It has been sold on the basis of the notarized agreement. My lord, notarized agreement is at price 61.
Yes.
To different persons. Deity is not getting anything, but persons with a notarized agreement are selling the land. When this came to knowledge, I filed the writ application. In that writ application, it was directed that Endowment Commissioner to take step. Endowment Commissioner verified, yes, it is true. He admitted that, yes, it is true. Thereafter, he did not take action. Lastly, I also came to the Honorable High Court, directing that the Endowment Commissioner should take immediate step to take back the land. That has been directed. It is out of these anguish, out of these events, those suffering persons who have sold the land, they filed an FIR against him. My lord, the FIR was also final report. FIR was also, the FIR was closed.
And thereafter they file 200. Protest petition and public.
Yes.
I'll let you know. Issue notice. It has a checkered history. Because I think you are doing less professional work more in this.
He is a Congress committee of secretary.
This petitioner.
Yes. Pradesh Congress committee of secretary.
And a lawyer.
Yes.
Notice.
My lord,
What is this case?
no, yes, my lord, but there is a fact that once NBW was issued, either 205 I filed the petition. Thereafter, the court did not allow the 205 petition. My lord,
NBW order?
NBW, yes, NBW, I have been granted by bail by the criminal division case. By the
Stage up to the.
But that is in the trial.
What is stage? Trial, I know.
The evidence of the witnesses, that is the evidence of the prosecution witnesses.
You seek adjournment. Let's count for the petition. Submit that you move up.
Thank you, sir.
Yes.
97.
Yes. 97.
97.
Defect 6. What is defect 6? Huh? Non-APS subject. Yes.
101.
On behalf of Mr. Das, I prefer an adjournment, Your Lordship. In the meantime, I will remove the defects.
Yes. Then Council petitioner seeks adjournment to cure the defects. Yes.
Obliged.
102.
क्या हो गया 102 में डिफेक्ट 3 and 10 है मतलब ये defects pointed out is not yours. One which time is granted to cure the defects. Defect is not yours.
May I please, my lord? Lordship, I mean DC. I'm praying for an adjournment, my lord. In the meantime, I will remove the defects, my lord.
Since the adjournment was for clearing the defect. Yes.
God bless, my lord.
Which one? Six. That's the reason we actually they are interested. The other yes, 104.
Euro sorry, do it. One. I'm sorry. बाहर 96 देखो.
देखो display.
96.
What is this going on?
अरे भूल भटका हुए समझते हैं सेम difficult.
Passing peremptory orders and people must be waiting outside.
କିଛି ଅସୁବିଧା ଆପଣଙ୍କ ଘରେ କିଛି ଅସୁବିଧା
ବାହାରେ ବସି କଥା ହଉଥିବେ ଇଆଡେ
ଏତେ ବାଟ ଯିବ ବୋଲି 100 କ୍ରସ କରି କି ଜାଣିନା ଆଜ୍ଞା ଆଜ୍ଞା ଆମର ବି ଜଗିବା କଥା ଆମର ବି ଦାୟିତ୍ୱ ଅଛି
चेंज हो टिके रही जाओ
लेट्स लो
96 लेट को जानतो आकडा आसु तापरे 100 आपनकर कोटा
मोर 102
लेट अस टेक अप 102 यस
102 रे मोटे आई हैव चैलेंज दैट annexure 6 पेज 27
नो नो प्लीज कर काट दियो 100 सारा यस Yes, sir.
So, annexure 6 page 27 is impugned before us.
6.
Only the legal point here is the order is passed by the SDM under section 133(1), which is introductory order or interim order. So against that, under section 397(2) is a bar to file revision. It is not maintainable. But saying it as maintainable, you will also see the revision is decided. It is only my point. 102 and 108 arising out of the same
the impure order is
page 27 words, annexure 6.
No, the 133 CRPC final order was passed.
No, interim order 133(1).
Where is
Yes.
that order?
Order is my lord. That is on annexure 5.
5, huh?
My lord, page 23.
How do you say it is finally disposal?
It is interim order. Your lordship may kindly see this.
Where is that? Which part?
Your lordship may kindly see page 25.
25?
The ordering post. Yes. In view of above discussion and observation, I am convinced that the people of Goda Khoroda are feeling suffocation due to fly ash just during the regular manufacturing of fly ash bricks by the second party
Directed
member.
to maintain peace in the locality.
Yes, and put up on 28/2/2023. It was directed for inquiry and put up on 28/2/2023.
Directed to go for a personal inquiry.
Right.
Yes, Mr. Ragada.
But they but not malad even the copy malad. And also private party. And then no malad, not given. I will survey copy. I am sorry.
133, the order was passed.
Malad.
And it is an interlocutory order. Revision is not maintainable. Revision court entertains and pass the order. That is it.
Malad simply should notice the private party malad.
Yes.
108 and 102 both are same.
108 also. 108 is issue notice.
This same. Go to copy.
Immediately after vacation, these are matters.
102 खाली मैं गोटे may I pray interim order that annexure operation of annexure 6 be stayed.
What is the consequence? The inquiry will go on. Why do you stop inquiry?
So it was quashed. So that inquiry was quashed. Everything was quashed. That is the order passed by the SDM was set aside.
Chalo, without jurisdiction order is passed, then it has to be stayed. Right, stay. Stay the execution of impugn order.
Yes.
One thing,
Operation of impugn.
my lord, whether the 133 proceeding, my lord, final disposed of, or my lord, the
No, it's not. Interlocutory. Inquiry report is sought. That's what I was looking at.
Yes, Your Lordship.
Inquiry report from Tahsildar was sought. A matter was adjourned.
My lord.
And that order was challenged in
Revision.
397. And it was
My
so therefore it's in right. Operation of the impugn order dated so and so is stayed till next day. Yes. 102 and 108.
Same fact. But two parties are there, therefore two.
Next.
104.
May I please, Your Lordship? Lordship, I pray for 1 week time for removal of the defects.
Yes. 6 1 week time for curing.
My lord, it is connected matter 10456.
Yes, Your Lordship.
4 5 6 all.
Yes, Your Lordship. All
1
are
week.
correct.
See,
Yes.
1 week time only I am giving. If you don't cure, then it will be dismissed.
Yes, Your Lordship. I will do.
Okay.
The matter. Yes, sir.
1 week. By way of last and final opinion. Yes.
Obliged.
107.
Whatever defects are there, I will remove it. This is a matter for quashing of the proceeding on the ground of compromise. I will procure the attendance of that informant.
When?
After vacation. Okay.
On request, huh? Bring them and we will pass it. Anand.
Yes, I will.
Bring them.
Yes.
Forget about the defect and all.
Yes.
If you bring.
I will.
Yes. Next. 109. 109. Same. Defect. See, these matters are pending. Nobody is, bothered. That is the reason I told them to list it. Many petitions might have been infructuous. Yeah, sir. Infructuous is who bother. Right. The defects pointed out the registry has not been cured. None appears, huh? None has not been cured. 2 weeks time is granted a last and final opportunity to cure the defects. In the event defects are not cured, the petition would be shall be dismissed without reference to the court. Yes. 110. 10. Then he's coming. 110. Yes, sir.
My case is on.
But you have not cured the defect anyway, whatever defect may be. Tell me.
On dated 30/8/2023, the informant lodged a FIR to the effect that they are cultivated a government land since 12 years and leave their livelihood, but on dated on 30/8/2023, it is alleged that the present petitioners, namely Dhaneshwar Haripal, Dameshwar Haripal, Kumar Haripal, Aravind Haripal, Kausalya Haripal, Govind Haripal, Surabhi Haripal,
Don't read all the names. There are many names.
Haripal. Titles are Haripal. Haripal came and attempted to assault by means of sticks, as etc. by using.
These are the allegations. What?
Case counter case.
Yes.
Counter case. That's what
Counter case 506. ଆପଣ ଇନଫର୍ମାଣ୍ଟ କୁ ପାର୍ଟି କରନ୍ତି ଗୋଟେ ନୋଟିସ ଦାও କମ୍ପ୍ଲେନ୍ ସେଟଲମେଣ୍ଟ ହବ
ସେଟଲମେଣ୍ଟ କରିବେ
ଆଜ୍ଞା
ସେଟଲମେଣ୍ଟ କରିବେ ଇନଫର୍ମାଣ୍ଟ କୁ ପାର୍ଟି ବନାନ୍ତୁ I will issue notice once you complete. ଏବେ କରିବେ do you have the address and
party informant କୁ ପାର୍ଟି କରନ୍ତି.
Do you have the address and address of the informant?
ଏଫଆଇଆର ଆଡ୍ରେସ ଅଛି ତାଙ୍କୁ ପାର୍ଟି କରନ୍ତୁ ନୋଟିସ ଟେ ଦେବେ
ଠିକ ଅଛି
କରୁନାହାନ୍ତି then counsel for the leave of this court to implead opposite respondent informant as the opposite party number 2 during the course of the issue notice to opposite party. ଆପଣ ବର୍ତ୍ତମାନ କରନ୍ତୁ ହାତରେ notice ହେଇଗଲା ଦେଖିବା yes next 113
111
My lord,
mention 11 11 12
13 my lord, I am there in DC my lord, kind. Yes, my lord.
Yes, there are some defects are there. 2-3 decades I may permit to defect, remove the defect in 1 week. I may provide kind permission, my lord. I may add the informant because it's a matrimonial dispute, 492 case. So I may kindly permit to add the informant as a opposite partner too.
498A.
My lord. And interestingly,
You edit, I'll issue notice.
Yes.
Cure the defect meanwhile.
I'll mean kindly.
Mr. Lalit, Mr. Land Counsel for the why are you standing far away? You come front.
Yes, my lord.
You have instructed
my
your
assistant.
junior to stand in the back.
No, I had told to stand in front of me because in the meantime 2-3 items have gone, so it may not be.
Just now you implead the informant.
Yes, my lord.
Then, Mr. Lalit Mishra and Counsel for the petitioner seeks leave of this court to implead the informant, opposite party number 2. Opposite party number 2. The matter is arising out of a matrimonial discord. Issue notice to the opposite party. Shall I send you to mediation straight away?
Yes, my lord. I'll be obliged.
You better explore the possibility.
Yes.
The
My
same
lord.
thing.
My lord.
Even on discord, the petitioner is seeking quashing up for the. What about the marital this thing disputes? Whether you file any divorce petition, anything?
No, my lord. I have filed a restitution of conjugal rights. I want to bring my wife back.
Then there is a chance of settlement.
Yes, I have filed. I have annexed the annexure. Kindly see annexure 2 series.
Mr. Mishra further submits that he has also filed an application under Section 9 of HMA Act for restitution of conjugal rights.
Annexure 2 series, my lord.
Which is placed as annexure P2. P2. Since the dispute is arising out of matrimonial dispute, there is all probability that the matter would be settled on mediation. Therefore, the parties are directed to appear before the High Court Mediation Center on a date to be fixed by the coordinator of the mediation cell. Issue notice to the opposite party number 2, retainable on such and such date of immediate vacation, awaiting the mediation center. The coordinator of mediation center is directed to place on record the mediation report by the next date of the
My lord, I may just inform that also a divorce petition is also filed because
in the meantime, proceeding before so it's take.
Yes. You'll also indicate divorce petition though is filed. I'm not pressing now. You'll also because I have to disclose the fact that I initially filed a section 9. No. I have filed. Initially filed a section 9. Then also divorce. That's why you will also indicate authorized mistake of my submission.
And also
Divorce petition.
Thereafter filed a divorce.
Why?
Yes.
114. Where my lord had taken notice to the informant to explore the possibility of compromise. But in the meantime, he has died.
Who died?
The informant has passed away. The noting has come.
What are the offences?
The offences, my lord, 468,
467, 468, 471, 420, 120B, 32 BF STSTR.
What to do?
What do we
Lordship, after vacation, Lordship, hear this matter.
But you have to, if you want a settlement, you approach the LRs. They may come forward and.
I'll try. In the meantime, I'll try that.
That is a better idea.
Yes.
If they come forward, we'll stop it. But
yes. That was the reason why we had taken notice. Let it come after vacation. Let me see.
Notice was issued to opposite party number 2 for the informed. However, it is undeliverable postal. The postal. It is
postal endorsement is there that the
where is it?
The notice search.
Yes, no, in the cause list it is written.
Yes, cause list.
The postal endorsement indicates that the addressee has expired.
Yes.
Therefore, the notice could not be delivered. Mr. Paul, legal counsel for the petitioner submits that he will take necessary steps to see that necessary steps in this regard. Please, sir.
After that.
115.
May I please, my lord?
My lord, in this case, the challenging the order of convenience in a private complaint, my lord. And here the complainant has also entered into appearance, my lord. And cognizance has been taken on section.
Complainant is there.
My lord already entered into appearance. OP number 2.
Where is he? Where is he? Nobody is coming.
115 na?
Yeah.
115.
Display, therefore, display.
115.
Huh?
115.
113.
Set at ये देख लो.
113.
Notice.
No, no. 115.
Hmm?
115.
113 देखो क्या? Abela.
Letters.
Yes.
My lord. My lord, cognizance on section 341, 294, 323, 379, 406, 420, 506 by 34 IPC, read section 31 RS of the SC and ST Prevention and Atrocities Act, my lord. My lord, the petitioners are the husband and wife. My lord.
If somebody is there, then only it can be heard.
Appeal question is.
Appear. Yes, yes. It is OP number 1, only the complainant he has been made and petty.
Sangram.
What to do? In his absence, there's no harm. The idea is to settle the issue. He could have come.
Mobile number देते हो? Mobile number. Mobile
ना.
Mobile ना file?
Mobile ना file is ना कारण तम ना. Mobile number. ये दे ले.
एक कुछ सिर्फ में रखो बिल्कुल. 21st. Otherwise, I will have to stay.
My lord.
21st.
My lord.
That's very good. Please.
My lord.
Wait.
116.
May I please, Your Lordship? Your Lordship, in this case, the petitioner is challenging the cognizance order dated 29/2023.
Yes.
Your Lordship, kindly page 18, kindly under annexure 4, Your Lordship.
18.
This matter is under section 138 of NI Act, Your Lordship.
You are accused.
What? Yes, but the check has been issued. That 2 checks were issued in favor of my wife and daughter, but they have filed a complaint against me, the present petitioner, Your Lordship. Though as per the provision of law, Your Lordship, under section 142, this check.
Where is the check?
Your Lordship, kindly, Your Lordship, turn to page 10 under annexure 1. That is a complaint case.
Complaint case. Yes.
Yes, Your Lordship. Your Lordship, kindly come to paragraph 8.
Gopal Meher.
Yes, Your Lordship. 2 numbers of checks bearing check number so and so dated so and
Gopal
so
Meher.
in the name of complainant's daughter Madhusmita Sahu, and 1 check is Gitanjali Sahu, wife and daughter. The 2 checks were issued in favor of the wife and daughter, but he has filed a complaint against me, the husband of the.
When notice was issued, you had replied.
That is, Your Lordship, I have annexed, Your Lordship.
Where is that?
Your Lordship, that has been issued, and I have appeared, Your Lordship. Kindly come to the running page 18. On 12/10/2020.
No, I am asking something else. Legal notice was issued to you or not?
Yes.
You have
No,
replied?
not in my favor. Because of a check has been issued to the present petitioner's wife and daughter. That 2 checks were issued. As per the provision of law, Your Lordship, kindly come to section 142.
No, just see. You are missing the main thing.
Yes.
Come to 8. Complaint. Para
Yes.
8.
Yes.
Check. It is written by check or checks were issued.
Yes.
Next, number 2. Of office copy of the pleader's notice dated so and so along with the postal receipt.
Yes.
Thereof issued to accused. You
Yes.
are the accused.
No.
That is postal so and so between the complainant and the accused.
But the Gopal Meher, the husband of the, those two checks
Do you
were.
have, do you have any doubt regarding my understanding?
No, no, no.
I understood it.
Yes.
When check notice was issued to you, have you replied to that or not? Saying that the check were not issued by me, check has been issued by my wife and daughter. Have you answered to that?
In pleader notice.
Huh.
No, that
I am 100% sure the pleader notice would have been husband name, wife and daughter. Show me the pleader notice.
Your Lordship, I will show. Kindly take.
I have not seen it, but this must be the.
Yes, yes, I understand. Kindly call on Monday, Your Lordship.
Monday. ये कौन करती है हस्बैंड सब करती वाइफ ना ये करती
नहीं नहीं नहीं
लीगल नोटिस तीन जन ना लिखा
I am the purchaser, Your Lordship. What happened in this case?
You get the notice.
Yes, yes.
You have a case. Direct
Yes,
you have case.
yes.
This 138 petition is
Only-
not maintainable again.
Yes, I pray, Your Lordship, the check should be issued in favor of the payee. And the case may be lodged against the.
Yeah, 138 so
Yes,
406 was
yes.
complaint is apart from 138 406 is also there.
Yes.
If 138 is goes 406 may be against you. So let us see.
Yes.
Don't make it so simple.
Call on Monday.
Monday.
Yes. I love bless.
Yes.
117.
17, may I please your lordship? My lord, today the petitioners before lordship with a very small prayer. Monday, coming a Monday, he period. A Monday, he period. Both tough.
Fresh matter.
No, fresh matter is all right, but minimum document you will not file. You will not do any research. And you want that the court should do it.
Tuesday, any day. Next week, any day.
Next week, both.
Well, I will take
150, 170.
I will, Your Lordship, may I pray, Your Lordship, I will take the notice. And meantime, Your
I'm
Lordship.
simply issuing notice. Huh? That I
Only
need to
sort of-
Don't ask for interim order because you have not filed complete.
Only that much, Your
So
Lordship.
no. Then
Kindly
this
consider
is
that.
unfair on your part. You without preparation, without filing document, you are coming. I'm giving indulgence because of
In complaint case,
all
one
right.
thing more I will place, Your Lordship, may I call me?
cognizance is taken under which section?
That is 138.
And 406 is also there.
No. No.
406 is also there.
Your Lordship, kindly turn to page 18.
117, huh?
Only 138.
Tell us, letter counsel for the petitioner would move appropriate application for seeking adjournment owing to the fact that the matter is should be ethically issue notice. The same thing will happen. Why? Yes, next.
117.
My lord, may I please your lordship?
Yes.
My lord, the petitioners before lordship today with a very small prayer. Last occasion, lordship had this matter and posted it to 25/6/2024. And that I have intimated to the Lord court below. I pray, my lord, till your lordships has fixed it to 25/6/2024. I may be permitted for only adjournment till your lordships that.
Vivekananda Bhuya for OPID. It should have solved the copy because yes,
They given that relief to you.
No, my lord,
There
no.
must be some problem.
I only a small prayer, my lord, till your lordship, the dead your lordship.
There's a small prayer in absence of the opposite side.
खाली हम copy
What are the offenses?
my lord, OPID is there, so 6.
OPID is there.
My lord. Initially, they have released it on bail, my lord.
That's not
No,
the issue. Issue is
I
issue is I can't stall the trial like this.
no,
OPID.
I doesn't want that.
Many people were there. Immediately I stall it, then
Up to your lordships that order. Up to your lordships that fixed that matter. Till that day, I file a petition
I understand, sir. What this matter is fixed for what?
for appearance.
Appearance of your appearance.
My lord, the mother, elderly mother, and
You should appear.
my lord, because my lord, when I was
I'll record that you will appear and seek adjournment.
my lord,
Okay.
my lord.
Let him appear at least. Right.
No, I am ready, my lord. We have no role.
You appear that Sushila Agarwal will help you.
See, OPID, my lord, in the OPID court.
No. Sushila Agarwal will.
With the
Wherever offense is added,
Madam.
then Sushila Agarwal is there. No, your lordships that directed, I will appear.
I am
taken.
giving you some idea and you want that.
No, from the beginning, I have read that.
Then counsel for the petitioner submits that although the matter is adjourned to the main matter is adjourned to 25/6/2024. However, the trial court is proceeding with the matter. Proceeding with the matter. Therefore, he submits that he would be moving application seeking adjournment. He would appear before the court and move application seeking adjournment owing to the fact that the matter is submitted before this court. If such application is moved, same shall be taken.
Hon'Ble. Hi.
Mr. Vivekananda Bhuyan.
Vivekananda Bhuyan.
Name may be
Reflected.
in the cause list.
Cause list is reflected.
Cause list as more liquidated.
Hon'Ble.
He's taking advantage of that.
No, my lord, no, I am not taking that. But I dispose.
Dispose of. I dispose.
May I please, Lord, sir?
Yes.
My lord, the place for the quash the proceeding down of the compromise, my lord. Last occasion mediation center ଯାଇଥିଲେ report ଟା ଆସିଛି ଏବଂ notice ଯାଇଥିଲା notice ରେ କେହି appear କରୁନାହାନ୍ତି opposite party number
Mediation successful.
ସେଟା successful notice ଟା ଫେରି କେହି appear କରୁନାହାନ୍ତି notice sufficient ହେଇଛି କିନ୍ତୁ
नहीं mediation successful ହେଇନି ନା
successful ହେଇନି second time ହେଇଥିଲା third time ରହିଥିଲା date
Report ଆସିନି?
report ଟା ଆସିଛି
Mediation report is at flag 2. Flag 2.
flag 2 ରେ ଅଛି
Who is Lakshmi Devata? But she is not cooperating, so mediation fail.
ଛୁଟି ପରେ ଆସୁ ସେ ଯଦି appear କରିବେ
The matter was sent for mediation by this court. However, the mediation appears to have been unsuccessful, and the report has been laid down by the mediation cell before this court. Let the matter be listed on Sunday for hearing. Yes, sir.
119.
May I please, Lordship? My lord, quashing of criminal proceeding. The ground is that the matter has been amicably settled between the parties.
Bring them.
My lord.
Bring them. When?
Monday, my lord.
Not Monday. Next week you just forgot. 16th. 16th.
So they put some matters.
16th. Okay.
Aye.
Bring them. Don't waste time, huh?
My lord.
Yes.
121.
This case, I am for the petitioner. Lordship, last occasion issue notice, but nobody has appeared, man.
Service is complete. We check it up.
Tracking report ଆସିଛି
No, incomplete. Service incomplete.
Service awaited. Service on respondent to awaited. Urgent. Yes.
after vacation, man.
122.
Same, ସବୁ ସମାନ 24% same. 24.
Up to 24 cell.
Same. Can I pay one thing, man? Lordship, till that one not to take any coercive action. Lordship, when I act matter can be settled. If they will appear, the matter can be settled.
Settle the service. You should have taken step to serve. 138. How can I?
ठीक है.
You are the accused.
I am the accused.
How many checks?
4 cases, 4 checks, my lord. Admittedly, he has taken money, my lord. In the cross examination, he has admitted, my lord. He has taken
4 checks. Each
4 checks. 4 checks. Different 4 checks, 4 cases.
I know that. 4 checks. Therefore, 4 cases.
My lord.
What are the amounts?
Amount different, my lord. The sorry. Amount, my lord. And the 8 lakhs 50, 8 lakhs 50, 4 lakhs 60, 5 lakhs.
If you deposit 20%, I'll take.
Then the lordship court has directed to deposit 10%.
10%. You are challenging that order.
That order, my lord.
Then
lordship give us after action.
125.
I have taken service of notice.
awaiting.
Awaiting service of notice. Non-appeared, for petition. But careful to choose non-appeared. Non-appeared, non-appeared. Right on. Next.
126.
Ma'am, please go on.
Item 120. Beg pardon, Your Lordships. I am appearing. I have been instructed by the opposite party, Your Lordships. Yesterday, the opposite party got the notice, Your Lordship. I have been instructed to appear, so I will file my Bhinama. May kindly put up on any day next week, Your Lordship.
There is an application for interim stay, my lords. There is an application for interim stay, my lords. Interim stay is the process for the learned court below.
I may kindly be heard, Your Lordship.
What is this matter is about? You are
There is
seeking what?
about, here in this petition, my lords, the petitioner has challenged the order passed by the learned court below under annexure 5 series, my lords. When in the petition of the petitioner to send the disputed checks to the FSL for am I audible, my lords? Am I audible, my lords?
Yes.
The petitioner has challenged the order passed by the court below under annexure number 5 series, my lords. Wherein the petition of the petitioner to send the disputed checks to the FSL for examination of the handwriting, my lords, of both the parties.
Mr. Pradhan seems to be not ready. Notice has been issued. He has entered appearance. Let us see.
Interim order, my lords, at least.
What interim order? You seek adjournment.
My lords, I prayed for the stay of the proceeding before the court below.
Mr. Pradhan will be agreeing, then I'll pass the interim order.
How will he agree, my lords?
I have
He is
objection, Your
the
Lordship. I will have my objection, Your Lordship. So kindly, I may kindly be heard.
So both of you go and get an adjournment there. Trial court. Yes. Next. Yes.
127.
May I please? In this case, Lordship, the
One line, 2 lines I will place yours. I'm not.
I will not hear you. Because you are creating problem for your mother.
No, Your Lordship. No, for a moment.
Or only for property.
Kindly consider for a moment. Kindly come to Your Lordship may direct.
Yes.
But Your Lordship, for a moment, kindly come to page 44.
44.
Yes, Your Lordship. Only that much I will place. Your Lordship.
44. Okay.
44. Your Lordship.
Definitely.
So may I permit to read, Your Lordship?
Yes.
Yes, Your Lordship. Your Lordship, in last paragraph, middle line, I am reading in the portion of complaint ASI N Dolai issued letter to RDA. Your Lordship got it?
Yes, I got it.
Udit Nagar to provide the details of the sale deed of the house, that is Quatan so and so, phase so and so, so, and receive the same in who is the secretary of RDA, Udit Nagar, Alkala has mentioned that the dispute of the family members are civil in nature. Any step will be taken by RDA may lead against the complaint court of law, and any decision taken by the court of law will abide the RDA. So
what do you want to show?
Your Lordship, that 2 affidavits which was filed by the mother, that has been forged signature, Your Lordship. Only
who forged?
The false signature is put in her affidavit.
Your mother?
Yes.
So therefore,
I am
you
not
want to send her to jail?
No, I am not in that, Your Lordship.
What then? What do you want?
You
are
Lordship,
prosecuting your mother, and you are talking about all these things.
Your Lordship,
Because you people, your brother and sister, everybody is fighting for property. You are using your mother. She is 81-year-old.
I understand.
I'll pass it. You tell me.
Affidavit dita file kale, that has been already sent to the expert.
You keep on fighting with your brother. No problem.
And cognizance has taken by, Your Lordship, kindly turn to page 45, Your Lordship. 45. Your Lordship, for a moment, Your Lordship, kindly See,
I agree. Whatever you say, I agree. Your mother has done everything, but she is still your mother.
ସେଇଥିରେ what as per my instruction, your lordship, ସେମାନେ ମତେ ଘରୁ ବାହାର କରିଦେଲେ ବାଡେଇକିରି, even if after the death of the mother, ହଁ ଭାଇ ମାନେ ସମସ୍ତେ
Have you lodged any complaint against your brother? No complaint
your
against.
lordship for a moment, your lordship.
What is the stage of the trial?
Your lordship, the
That has been
cognizance
stayed by
has
this
been taken,
honorable court.
and
The proceeding has been stayed by this honorable court, my lord.
Proceeding stay na?
export କୁ ଯାଇଥିଲା, export ପରେ ବି ଆସିଥିଲା।
Your lordship, kindly see Annex 1. She left the house since 1995.
That is also forged by the mother, your lordship, and the brother.
What I'll do is, qua the petitioner, I'll stay the proceedings. She may not go. Complete stay. And proceeding has already been stayed.
Yes, ma'am.
Qua the mother.
Only
Okay.
the mother is accused.
Mother is accused. Only mother. in
Only
the
mother,
affair.
my lord. No, he has not lodged any
behind
complaint
behind the
against
brothers.
Yeah. Just see,
So whoever is behind him, why don't you catch them?
he did.
your lordship for a second.
Mother must be staying with the other brothers.
ମତେ permit କରନ୍ତୁ ମୁଁ ରହିବା ପାଇଁ। ମୁଁ I am a
Your lordship, kindly see
ମୁଁ
Annex
metric
1.
pass କରିଛି।
Kindly see Annex 1.
person ମୁଁ only ମୁଁ ଝୁପଡି ଘରରେ ବର୍ତ୍ତମାନ 1500-2000 ଟଙ୍କା ଦେଇକି ରହୁଛି।
What beg I
Madam,
can
there are-
permit, or let the matter be sent to the district mediation, ଗୋଟେ report ଆସି ସରିଯିବ।
Mediation କାହିଁ ଯିବ? 82 years old. She can't appear. She
Can't
can't
go.
appear.
That's the problem.
ବିସିରେ appear କରିବ।
ଆଜ୍ଞା, 82 years. ମିଶିରେ appear କରିବ?
ଏଟା compromise ହେଇଯାନ୍ତା।
ଭାଇ ଭିତରେ
ଟୁଟି ଯାନ୍ତା ମା
Behind
ମିଶି ଯାନ୍ତେ
back in the
Sir,
behind
ମୁଁ
your
କଥା
lordship.
କହୁଛି, he has filed ଗୋଟେ minute ମୁଁ କହିସାରେ, he has filed a suit in 2018 for the sale of property, and the complaint was in 2020. Your lordship, kindly see Annex 1. He has received money in the year of 1995. He left the house since 1995, receiving 35,000 of rupees.
No, that is also false.
Anyway, see, this stay is there. You urgent to August. Let it be pending. Nothing is going to happen. She is protected. She is protected.
Your lordship may direct anything.
Very
Your lordship
even
was
civil in
object
nature.
just
There is
a
no
minute.
criminal antecedent.
Why?
Yes.
If your lordship will permit to send it to the
No,
medical center,
I will not agree on this.
my mother may be permit to leave that house, your lordship, because of my family.
How many cases are pending between your brothers and you?
No cases.
No cases.
You are don't answer to your mother.
What? No. What happened to in this case, your lordship? First of all,
Can I refer it to mediation and say that on behalf of the mother, the other brother and sister will participate?
that can
Yes, one.
that may
I'll send it to mediation, but mother will not participate in mediation. And
represent.
on behalf of mother, the other brothers will participate.
No, they may come, they may not come, because there is not a cordial relationship with this. Why are you asking to question me? I
I'm
will
not
Yes,
asking.
don't
I am
waste
submitting
time.
before the court.
I'm
Just
not-
wait.
I'm
Don't
also
waste time. I'm
Don't
trying to-
be aggressive. Don't be smart, please. I am submitting before the honorable court. My lord, what happened?
One person.
There is no cordial relationship with the brother, my lord. He has lodged a complaint against the mother. Mother is now 82 years. She is not in a stage to work also. How she will come to the mediation center and other
Then I
brothers
will
will not
say
come. And again, another thing, she has not filed any complaint against his brother, my lord. And he has also filed a civil suit. And civil suit is, though he is the plaintiff.
August last record. Interim order to continue.
Probably.
No, secretary, your lordship.
No, nothing doing. Do you want me to vacate the interim stay? What are you talking? I'm going to quash it. I'm going to quash it. If you insist, I'll quash it.
No, I'm not being smart.
What do you want? Your mother will go and parrot before the.
I'm not saying, I'm not in that.
What are you saying then?
I'm not in that. Your lordship, what happened?
How? Forget about what happened. What do you want now?
First of
I'm
all,
simply adjourning it.
How?
Let the matter be there. Your mother will pass away someday. Then the matter will automatically, buried. This is what you want.
no.
Go and fight it out. Yes. If they will continue. They will continue. Very specifically right out. They will continue.
130.
Yes.
Sorry, man. 125 just having the lead. 125. That
Reverse list. Wait.
এটা খালি রয়েছে আইওটিং সার্ভিস নো
Awaiting service.
সেটা କିଛି ହବନି କାରଣ ଇଏ
ନହେଲେ reverse way ରେ ଯିବାନି ଆଗକୁ ଟିକେ ଯିବୁ.
ଲାଷ୍ଟ ମ୍ୟାଟର ଭୋଟିଂ ମ୍ୟାଟର।
Yes.
130.
130. None appears. Interim order, none appears in the interest of justice. Urgent.
131.
This clipboard is the. Yes.
The present case is raised out of the family discord between the husband and wife. And I have become a prey of it. I am the cousin brother of the prime accused, who was already arrested.
In this case, I am for the opposite one of two.
That's
Lordship
it.
can see the prayer portion. My lord. What is the prayer?
Lordship,
What do you want?
yes. Lordship, in the FIR, nothing is being
Anticipatory.
specifically.
Prior to that, anticipatory bill has been rejected, my lord.
Lordship,
He has filed this case for a religion bill on surrendering. That is
yes,
the
Lordship.
prayer portion.
Lordship, nothing.
Therefore, there is a chance of settlement, therefore I will.
Nothing is being specifically alleged
The
against.
husband is arrested and he has religion bill, my lord.
Petitioner is the husband.
No,
No,
Lordship.
no.
I am
The petitioner is the brother-in-law, my lord.
Brother-in-law.
Brother-in-law. If a lordship can see the page 13, my lord, is the allegation against the present petitioner, the brother-in-law.
Yes.
Lordship, page 13, my lord.
That is what I am going to say.
That the page 13, my lord.
Read.
ମୁଁ ଏବେ ଜାଣିବାକୁ ପାଇଲି ମୋର ସ୍ୱାମୀ ଲଡ଼ସିକ
ସ୍ୱାମୀ ମତେ ବ୍ଲାକମେଲ
ମତେ ବ୍ଲାକମେଲ କରିବା ପାଇଁ ତାଙ୍କର ଭାଇ ଶ୍ରୀ ଜ୍ୟୋତି ପ୍ରକାଶ ତାଙ୍କ ସାହାଯ୍ୟରେ ମୋ ଶ୍ୱଶୁର ଘରେ ଥିଲାବେଳେ ମୋର ନଗ୍ନ ରହିତ ଗୁପ୍ତ କ୍ୟାମେରାରେ ଉଠାଇ ଭାଇରାଲ କରିଛନ୍ତି।
Lordship, that is the only allegation against me.
That's a very good dealing.
No, Lordship, but it is
For taking cognizance.
Yes, Lordship. No, my point is that
You have taken nude photograph of your
how
sister.
I can,
I don't know how I can.
I am the brother.
I'm not inquiring.
No, Lordship, no.
That happened, the investigation is going on, man. The investigation is going on.
I have also annexed the investigation.
After rejection of anticipatory bill, after this one.
ମୋର ମାନ ସମ୍ମାନ ହାନି ହେବ।
Lordship.
ଏଇ ତ ମୁଁ ସମାଜରେ କାହାକୁ ମୁଣ୍ଡ ଦେଖେଇ ପାରିବିନି। ମୋ ସ୍ୱାମୀଙ୍କୁ କଥା କହିବାରୁ ସେ ମୋତେ
ଜୀବନ ମାର୍ଗରେ ସମଗ୍ର ସହିତ ଦୁଇ ଛୁଆଙ୍କୁ ମୋଠାରୁ ଅଲଗା କରି ବିବାହ ରହିବେ।
All the allegations are against the husband of the.
This allegation, how will you get out? You have taken nude photograph of your sister-in-law.
No, Lordship. Nothing is being seized. Kichi that will be
Investigation is
investigation
the
open.
investigation is continuing since last 1 year.
Then I'll ask to
Anticipatory option rejected.
Anticipatory bail is rejected. That is what I am praying. I only pray that Lordship kindly
After
have a-
rejection of
kindly have a
anticipatory, he has
glance on
approved
page
this on the
18, the order which was passed during the bail.
Is it appellate jurisdiction?
No, Lordship. It is clearly that they have not adhered to the guidelines mentioned in the Arnesh Kumar judgment.
You should have argued in 438.
Lordship, no.
Arnesh Kumar and everything applicable in 438. That you got it rejected. Now you are challenging this cognizance. Investigation is going on, and allegations are so serious.
My only
And how
I am ready to.
you
I am
want
ready
that
to face the trial.
438 matter?
Lordship, I am ready to face the trial. I am ready to face the investigation. Everything
All these
is-
arguments are in 438, sir. Talk about quashing. In the face of this allegation, when the investigation is going on, can I do anything?
That is what I am showing. ସେ ତାদের ସେଥିରେ ସେ କଣ କହୁଛି ମୁଁ ଜାଣିବାକୁ ପାଇଲି ମୋର ସ୍ୱାମୀ ମତେ ବ୍ଲାକମେଲିଂ କରିବା ମୋ ସ୍ୱାମୀ ମତେ ବ୍ଲାକମେଲିଂ କରିବା ପାଇଁ ତାଙ୍କର ଭାଇ ସେ ଜ୍ୟୋତି ପ୍ରକାଶ ହାଁସଦାଙ୍କ ସାହାଯ୍ୟରେ
He has taken one nude photo reflected in the list.
Name is not reflected.
Yes, name is not reflected. And
Mr.
Sodipati-
Korida's name is not reflected because this the same may be reflected here. What is this matter? You want to file?
But after that, my lord, if lordship permit me, but the lordship kindly see the order dated 12/4, I think. And the order has been passed.
Yes.
Though anything dispute is there, but lordship has directed, this honorable court directed to deposit 1 lakh, which subject to matter will be stay. But till that, the
1 lakh
yes,
check manipulated to 10 lakh.
10 lakh.
Yes.
It has the allegation. But
That
bank has, it will be, my lord, found in the time of trial. Normally the bank, the manager will be appear and the trial will be, my lord, held. But at this stage, my lord, no, Honorable High Court, my lord, how to interfere in this matter, my lord, to safeguard his, my lord, point regarding the manipulation of check. So bank has already, so I have sent notice as per the after institution filed before the bank, instrument is filed before the bank, my lord, I have sent notice. They have not replied to my notice. Thereafter, I have due course, I have filed.
Yes, where is the legal notice?
Yes, I have sent you the notice. They have not.
And you have not filed response to that.
That,
Then presumption
Your Lordship,
operates.
actually, I am not ready today. I prefer next week, Your Lordship.
Not see, the notice was given.
Yes.
And that time you have not replied.
Yes.
Now the
That,
presumption operates. What to do?
Maybe taken over next week.
No reply.
No reply.
That I will take instruction
What
on that.
instruction?
No,
Your
what
Lordship,
instruction? The instruction is there.
And
Yes.
after that, they have not deposited the amount as directed this on report.
That interim order subject to
I'll
deposit
vacate
1
the
lakh, Your
interim
Lordship.
Yes, there is bracket.
I'll vacate the interim.
Yes, if any.
I saw the check, therefore I have given.
My
He
lord.
is now given the legal notice. Statutory legal notice. In statutory legal notice, it is written 10 lakh.
Yes.
Immediately you should have replied.
No, I will take instruction on
No,
that
instruction.
reply, Your Lordship.
The interim order pass on such and such. Mr. Porida enters appearance on behalf of the opposite party. The only ground, on which the petitioner has attacked the order of cognizance dated 8/6/2023 is that he had issued check of rupees 1 lakh in favor of the opposite party number 2. And the opposite party number 2 has manipulated the check and converted.
No, opposite party number 1.
Manipulated the check and converted it to 10 lakh. And presented the same before his bankers. The bankers have dishonored the check on the ground of insufficient.
Without any objection also.
Huh?
The bank must have, my lord, yes.
Insufficient funds. The petitioner has placed on record the subject check to persuade this court that the check is indeed manipulated. Mr. Porida enters appearance for the opposite party number 1 and place on record the legal notice, statutory legal notice issued by the opposite party number 1 to the petitioner, wherein he has very categorically mentioned the check number and the amount of rupees 10 lakh rupees. 10 lakh rupees drawn on SBI Bank, SBI Bazaar branch, Kendrapura. It is, he further submits that the petitioner has not responded to the legal notice, therefore the complaint has been filed. Since the petitioner has not replied to the statutory legal notice contemplated under section 138 of NI Act, the presumption under 139 NI Act operates against him. So therefore, the defense which has been raised by the petitioner could only be tested at the trial. I am not inclined to interfere in this matter. Therefore, the petition is dismissed.
Your Lordship, next week, Your Lordship only. I have not. Monday, Your Lordship.
Already written. The petition is dismissed. That much I'll keep it. Next week I'll do it. Well, I have made up my mind what to do.
But Your Lordship, kindly have a glance the check, Your Lordship. That is only
check I've seen. 10 is written. Thereafter, some
yes,
he has scratched somewhere. But the fact that he has issued notice, that is enough.
That I will take. Okay. That so far as a reply of that notice, I will take instruction, Your Lordship, on Monday, Your Lordship.
And also that
already in the complaint it is written.
Also not deposited the amount of the Lordship directed.
That
is also.
That is subject to interim order, Your Lordship, that amount.
135.
Your Lordship, maybe Monday, Your Lordship.
Okay, 135.
135.
Your Lordship, on behalf of the department, and the senior standing counsel is an accommodation. Maybe taken on next week also it will be.
My lord, 1/5 and also in 8/4/2024.
Next week it will be on Monday.
28 to 20.
Some problem. Sometime we have to.
Next week it will be.
Can you tell me orders? Under the heading of orders.
Oblige.
on behalf of
Interim order
counsel
continue.
for the opposite party. Adjournment is sought. Adjournment is sought. By way of last opportunity, the matter is adjourned to equity after.
Interim order to continue.
Interim order.
136.
I am for the petition, my lord. Now, prayer is to squash under Annex 1, which is passed by the ADC become executive magistrate. I have filed objection of 8/2/2024. The intention of the opposite party only to linger the proceeding and
My lord, may I
fill up their
submit
lacuna.
learned counsel for the petitioner very well noted the court was not functioning since last couple of days, since because election is going on, my lord. The court was not functioning. My lord senior for know very well the fact that I am not intentional taking action. Rather the court is not functioning.
Garita Arjun
Again, I say,
Nilin.
ma'am.
Setting
Where is my fault, my lord?
ADM ନଥିବ କଣ କରିବା?
The Tola court Mekadam pending, which is not maintainable.
Immediately after
Pass order passed by the Honorable Justice Subhash Parija.
1 minute. Immediately
Well-
after the video, 19th or 20th. Huh?
20.
My lord,
By that
obliged.
time,
Date is fixed on executive magistrate 10th.
10th, na?
My lord.
My lord,
19th. Yes.
19, my lord.
19th June. Yes.
Obliged, deeply
Yes.
obliged.
Next.
19
June.
10 तारीख को फिक्सिंग अच्छी डेट
अरे भाई 10 तारीख तो कोर्ट छुट्टी अच्छी ना 19 जून पे लगाई देखो आसु आसु यस
Grateful.
my lord, my prayer is the widow lady. The behavior of the opposite party was sporadic, violent, cruel, inhuman, and no civilized citizen of a democratic country can be able to endure it. Goda dhari ki kanduchi.
My
How
lord,
do you
that
answer
doesn't
this?
mean that widow
Fantastic
lady cannot
sentences which you have
create any
uttered.
disturbance, my lord.
ମୁଁ ଯେତିକି ତାର ଦୁଃଖଟା ଅନୁଭବ କରୁଛି ସେ କିଛି
My lord,
ଆଧାର ନାହିଁ ତଳ କୋର୍ଟରେ
that-
ମକଦ୍ଦମା ପେଣ୍ଡିଂ ଅଛି
that
ଆଉ
is
ଏଇଟା
not
କଣ
true
ମେଣ୍ଟେନ
at
ଭଲ
all.
ଏକ୍ଜିକ୍ୟୁଟିଭ ମାଜିଷ୍ଟ୍ରେଟ
That is
ଦିଟା ଗୋଟେ
not true.
ଡିଷ୍ଟ୍ରିକ୍ଟ ଜଜରେ ଡିସ୍ପୋଜ
Rather-
ହେଇଛି ଆଉ ଗୋଟେ ସିଭିଲ ଜଜରେ ଅଛି The order passed by the Honorable Justice, former Justice Subhash Chandra Parija. This is not maintainable.
Please don't take the name of judges. This is unfair. But it's only 147 proceeding.
Yes, my lord.
147 proceeding.
44 ହେଇଥିଲା ତାପରେ ପୁଣି 47.
44 cannot stay
serious
for
proceeding.
longer time. That
Serious proceeding. And the election is going on. The SDM must be busy.
yes, my lord.
Let us see.
ଆଉ ପ୍ରାଇମ ମିନିଷ୍ଟର ପ୍ରଧାନମନ୍ତ୍ରୀ ଯୋଜନାରେ ଗୋଟେ ତାର ଇନ୍ଦିରା ଆବାସ ଗୋଟେ ମିଳିଛି ଯୋଉ ପ୍ରାଇମ ମିନିଷ୍ଟର ଆବାସ ମିଳିଛି 2 ଲକ୍ଷ ସେ ବି ରିଟର୍ନ ହେଇଯିବ ୱିଡୋ ଲୋଡି ତାର କେହି ନାହାନ୍ତି
My lord, they are constructing, they have already constructed. Rather by the common passages which are in only way to our house, they are putting bamboos and construction marble over that road. So
No.
their
The
road
alli- The allegation of the opposite party is false, baseless and imaginary
my lord, their road is facing
in
towards
nature.
the eastern side, which is the common, which is their way a threshold. But they are now they are creating obstruction by putting bamboo and construction metal
No.
over the common passage, my lord. That is only an
My lord,
Indian
inquiry
business
report
mind.
submitted by the concerned
My
peace.
lordship may
There
see
is
the
nothing, there is no breach of peace, there is no.
Keep it on 21st of this.
my lord,
21st.
my lord, obliged.
138.
My lord, mediation is pending, your lords.
Mediation pending. Awaiting mediation.
Yes,
I think on the last occasion on 6th, I am for the opposite party. On 6th, it was there, and as per my instruction, it was unsuccessful, but report has not been sent.
Wait, let us.
139.
My lord, entry model may be continued.
The application will come.
Immediately after.
Obliged, your lordship.
139.
139, I'm on VC, my lord.
Hmm.
I'm on VC. Here, my lord, 311 petition has been rejected. And in this case, my lord, the counsel appearing for the opposite party number 2.
Victim not allowed.
Well, I'm saying, my lord, because victim is the wife of the petitioner, my lord, and they have a child, my lord, and which. So I remember they're living under the same roof, my lord. Under one house, they are living as husband and wife, my lord.
Show me your testimony.
Yes, my lord, and that is I've given the statement of the victim, my lord, evidence.
Where
the
is that?
state council, to the state council I have given, my lord.
Array, you give it to the courts, what state council will do?
Yes, my lord, then my lord, kindly be matter be adjourned to next week I will.
You want 311 application to be allowed without filing
Yes.
the testimony of the witnesses to whom you want to be called.
Then my lord, kindly be adjourned.
Yes, urgent, yes, 40.
Adjourned to next week, my date may be fixed, my lord. A date may be fixed, my lord.
Next week not possible, sir. Next week not possible. After vacation only. And we will do down to clear up IO.
2/11/2016.
Huh?
2/11/2016.
2/11/2016, huh? Yeah, we will do. Okay. Yeah, what is? If I leave me.
Yeah, same of the thing. 2/11/2016. Actually, balance may be like.
Yes. Hello.
141. May it please, Your Lordship. Thus, in this case, my lord, a stopper was issued to us, alleging that there are irregularities, my lords. And a 7-day notice was given to us. And we replied it within time. Before that, a complaint case was filed. Prior to replying of a stopper. Now, after hearing our stopper, they were satisfied that there was no irregularity, and they said, do not repeat this mistake and impose a penalty of 28,000. And thereafter revoke the suspension, my lords. Now, the complaint case in this, the cognizance has been taken without arraigning the company as an accused, wherein the allegations are against the company, and the chauffeurs has been withdrawn, revoked everything. Mr. Lordship was pleased to pass an interim order, and I had given an order of this coordinate based of this honorable court.
Huh?
And the state notes, and Lordship was had asked my learning.
Which is part 2?
State and Lordship had asked the state to inform whether it's covered by this Lordship order.
Are you ready?
Whether it's covered by this order or not. But same offense, same party. Clearly covered by this one. I've given it to him. He has it. He has it long back.
Yes, easy covered. Mr. Rao?
Yes, yes.
Covered.
Also informed this in the improvements and the provisions are already taken in the same allegation. Offenses are
Same melodies. Offense is also the same melodies. Lordship will find it at page 41. Annexure 4 is same offense again.
Same offense.
Again. Annexure 4, page 41 again.
Reporting Patwari.
Again. I direct when a company को accused करा है नहीं, and he is not also the director of the company again. He is nowhere connected with the company also. So इधर company he is not even not a party to the company melodies. Specific pleading भी नहीं चाहिए.
He is what is he?
He is nowhere connected with this company. He was with Rashmi
What about
Metallics.
this case?
That was Rashmi Metallics, my lords. See, Rashmi Cement भी तक पूरे चले गए.
Okay.
Thinking that he is also director here. That is the mistake, my lords.
In this case,
he was a director, my lords.
This company is
Rashmi Metallics. That was Rashmi Metallics, my lords. कारण संजय पटवारी ना दीथरो ही जो सहित में तंग ना आया. Offense is under 23 of the MMDR Act. Offense by the companies, my lords.
Right on. Shall I allow it? Right on. The petitioner is exploring the relief, the following relief, exploring the following relief in the present petition. Release, prayer relief. Mr. Amit Patnaik, and counsel for the petitioner submits that the petitioner has nothing to do with the company. Which company?
This is Rashmi Cements Limited, the licensee.
Nothing to do with the company, namely Rashmi
Cement Limited.
Cement Limited. The entire allegation is made against the company. However, the company is not implicated as an accused. He relies upon, therefore, he challenges, therefore, he seeks indulgence of the court for quashing up the ICC case.
That's 2cc case, my lord.
2cc case.
Yeah.
2cc.
92 of 2012.
92 of 2012.
Pending in the Court of Learned JMFC Budbill.
He relies upon a judgment of the order dated 4/5/2023 passed by the coordinate bench in criminal MC number 1724 of 2023, wherein the petitioner himself had essayed the similar proceeding initiated against him, pertaining to which company?
That was Rasmi Metallics Limited.
Pertaining to Messrs. Lasmi
Metallics Limited.
In that case, the petitioner was
a director. In that case, he was
in that case, at least the petitioner was the director of the company.
Yes, ma'am.
However, the coordinate bench has given indulgence and passed the proceeding on the ground that the company was not arraigned as an accused. Insofar as the present case is concerned, the petitioner has nothing to do with the company against whom
the complaint was
against which the allegations are made. Therefore, he is directly covered by the judgment of the coordinate bench dated 4/5/2023. 2023. The relevant would be to reproduce the order dated para 4, 5 and 4, 5 and 4 to 7. 4 to 7 for the order dated since the petitioner, Mr. Rahul appears for the state and submits that in fact the petitioner is covered by the order of the coordinate bench as referred to above. In view thereof, the petition is allowed. The 2cc case is closed.
2cc case number 92 of 2012.
92 of
12, pending in the Court of Learned JMFC Budbill. Deep level.
yes, no.
142.
But Honorable Mr. Mishra, I pray the matter will be taken up some other day. He's an
Yes,
accountant.
yes.
The intent order to continue, my lord.
And we want to continue.
143.
143 may I please minutes.
I want to sort it though.
Yes, sir. I'm for the respondent, my lord. In
I am for
140.
it, sir. I want to sort that though.
My lord, the
Adjournment.
this is an order against my lord.
Adjournment.
Revision is maintainable, my lord, in this case because an appeal has been preferred.
That could be said after in the urgent date also. He's asking for
As-
recommendation here.
As my lord.
144.
May I please, Lord? My lord, the prayer for the release of vehicle of the petitioner was rejected by the learned courts below, my lord. My lord, the vehicle is was seized since 19/6/2023, my lord. Until that, no confiscation proceeding was initiated, my lord. And
Why it is rejected? Where is the order?
Order reject annexure 2, page 10, my lord.
Yeah.
First petitioner preferred CMC before under section 457 CRPC, my lord. After that he prefers criminal revision, my lord.
Why it is rejected?
Yes, 17.
Page 17.
Here.
Yes, 17.
Hmm.
The first start, just above. From the bottom line of 6.
Hmm.
The minimum data from section 56 3 of the study states that the seat property shall not be released within tenants of the proceeding or trial, even on the application of the owner of the property for such release. Such fact has been held to the honorable court in case of Hon'Ble of the state of Orissa and another. The proviso regarding non-release of the Swiss property.
No, during the pendency of the proceeding.
Yes, my lord. But till that, no confiscation proceeding was initiated.
What about, is it pending?
No, my lord.
Issue notice, Mr. Maharaja accept notice, and seeks time to ascertain as to whether confiscation proceeding, vis-a-vis the, what is that article?
56.
Vehicle. Huh?
56 3 of forest.
No, no, what is that? What is he trying to release?
That is account.
Which is goods carrier.
Yes, my lord.
TRK OB truck
Open body, my lord.
truck bearing registration number CG
Yes, my lord.
10C
Yes, my lord.
9110.
Trying to ascertain that the goods carrier.
So has been initiated or not? No. List out. List.
145. 145, my lord. This is relating to the rejection of the prayer for release of vehicle on the ground that 52A is a bar. Last occasion, Lordship has issued notice, and the language on which it has been pretext on the which rejected that the vehicle is liable to be confiscated. Because my till date, my lord, no proceeding has been initiated for confiscation of the vehicle, and there is judgment that Lordship last occasion that your Lordship has delivered judgment, but I could not ascertain the exact number. But there is judgment of our High Court that even if there is a confiscation proceeding, it is not a bar for release of the vehicle. Because the petitioner is not the accused, is not an accused of the offense.
Ashwini Das.
And he is not an accused. Petitioner is the owner.
Where is the order?
Vehicle was seized on 21/11/23.
Impugn order, sir. Impugn order.
Set of case number.
Challenge
23.
5324.
Finding.
You are not an accused.
I am not an accused.
Your vehicle is involved.
Yes.
The petitioner has moved an application under 457 CRPC. Read with section 52A, capital A of NDPS Act for release of his vehicle, his car, namely a car, Creta, his car, Creta 1.5 MPL MT SX, bearing registration number, it is page 19, which has been turned down by the petitioner. Learned consequently, the petitioner submits that the vehicle was in connection to which case? FIR number बताओ.
In connection with PR number 8185.
Boinda Excise PR case number 185 of 2023 for offense under section 20B1 to C of NDPS Act. NDPS Act. The court below rejected the application of the petitioner.
Well, the decision denied upon by my friend, on that basis,
Right. Inter alia stating agent, para 5 of the order, page 21. Para 5.
Para 6 last.
Para page 23, para 6 corner. No, ida corner, para 6, having gone through. Page 20, para 6. Para 6. Para 6. The perusal of the impugn order indicates that the trial court.
Simple pending of constitutional proceeding is not a proceeding. That is not the interest of the litigation. If the actual proceeding is continuing, that will be taken into consideration. Then the vehicle will be released. If at all the proceeding is not continuing.
Continue. Right down. Indicates that the application of the petitioner under section 457 CRPC is rejected solely on the ground that under section 52 capital A1 there is a bar for release of the vehicle. Release of the vehicle.
Yes.
However, contrary to the finding of the court below, this court has laid down the law inter alia stating that mere filing of the confiscation proceeding shall not
operate as a bar to release the vehicle under section 457 CRPC unless there is a concluded confiscation proceeding. Unless the confiscation proceeding is concluded and appropriate order is passed. And the land council petitioner relied upon two judgment of this court, so and so, so and so. Any paragraph you want to, which paragraph?
My lord, paragraph that in Pasunidas, my lord.
Which paragraph?
My lord, that is para 10 and the para 7 and 10. Para 7, 8, 9, 7, 8, 10.
What relevant you say that you
Yes, my
show the
lord.
paper and I want.
Yes, my lord, that relevant, my lord, what the seizure
Where is the ratio DND?
ratio, my lord, that was decided in para 12, my lord. What is the proceeding what has been discussed, my lord?
Para 50. Para 50. You people are not really reading properly. That's the problem. You have to come with pointed this thing.
Yes, my lord. And in that subsequent judgment, my lord, that is para 11. Then
Mr. Maharaj,
Yes.
all these things are relating to section 72 bar.
yes.
What about 51A? Have you checked it? These two judgments are relating to Excise Act under section 71 bar.
Yes.
Both the judgment deals with that. What about the bar under 51A?
That is what mentioned.
Where? Which paragraph?
Para page 23.
Impugned order.
23.
Yeah. Ashwini.
No, my lord, impugned order.
Important.
Huh?
23.
Now I am talking about these two judgments. How will you apply these two judgments in these facts?
There the court holds that even if the pending of a completion proceeding, vehicle can be released. The intent of the litigation has been clarified that the pendency, simple pendency of the completion proceeding is not a bar.
Yes.
Actually, the proceeding is continuing.
I am asking something else.
Yes, that is.
I am asking how will you apply these two judgments into fact of this case? This is dealing with the bar under 72.
And my lord, the ratio decided in that Ratnakar Behera, relying upon the Sundar Bhai Amala Desai, my lord, and various judgment, lordship kindly have a glance to para 8 of the judgment. Lordship. Lordship, para 8. Further, several jurisdictional high courts have decided against keeping the vehicles in custody for a prolonged period. The general law relating to release of the vehicle seized in connection with the crime pending investigation or trial by the magistrate in the most universal of its dimension has been laid down by the Honorable Supreme Court in Sundar Bhai Ambala.
Where are the judgment which deals with 51A?
Lordship, that I found one lordship last occasion. Lordship said that lordship has delivered a judgment, but I could not able to find because the lordship
These are 72.
lordship lordship last occasion lordship directed me. I could not trace out the exact number. That's why I could not.
Draft judgment reason. You give a draft, whatever dictation I have given. Will be a draft.
Lordship last occasion lordship directed me that lordship has judgment
that there you research it.
Lordship, I researched, but I could not get the number, my lord. That's why.
You want me to? You say share your fees. I'll do it for you. Your research is very
because
careful. You are relying upon 72 Excise Act is something different. And 51A is something different.
Yes, separate.
NDP is a draconian law. It has to be applied in a different platform.
Yes, yes.
You have to get those judgments.
Don't prepare and anything and okay, I'll see. Yes, next.
146.
Oblige, my lord.
If you get hold of any judgment and please research and give it writing.
My lord.
I'm reserving it. I have dictated whatever I have dictated. Let us see.
My lord, by Monday I will help, my lord.
Please do little research,
My lord.
which will help in other matters also.
Yes, my lord, yes. By Monday I will prepare.
Is that your MAK for?
My lord, by Monday I will give a written
Monday,
notice.
Tuesday, let it be
My
Monday,
lord,
Tuesday,
my
no
lord.
problem.
My lord.
But come with material. You may lose this case or may win.
Yes, my lord. But it will
now
help
I have
me.
to be laid down so that it will help to others.
In the long run, it will be helping, my lord.
So please do the research.
My lord.
The difference between 72 and 51, what are the differences? You read both the provisions and we will deal with it.
My lord.
And give a written submission.
My lord.
Peter, लिख ला पर लिख दो written submission will be submitted.
My lord.
Detail, exhaustive.
My lord.
Deal with all the High Court, Supreme Court, wherever it is there.
My lord.
Yes.
146. On behalf of my senior, Mr. Vansitar Bag, I prefer next week, my lord.
Urgent. Yes.
In that matrimonial, I have appeared for opposite partner of 4 on yesterday. My name may kindly be reflected.
Mr. Satyaman.
Opposite partner of 4 letters.
I told you that you should help the court in some revision matter. You are evaporating.
That's right.
We want some assistance from senior lawyer like you. You render some assistance so that we can finish up from some.
I will be
revision.
highly grateful, Lordship, if some matters are allotted to
Yes.
Lordship. It's not an issue. Grateful, Lordship.
Mr. Maharaj, please remind me. We will
Yes.
take his services.
Yes.
Okay.
Grateful, Lordship.
Yes. Two revision. 1 minute. There are 2 revision petitions.
147.
147.
On behalf of Ashok Das, pray for after vacation.
So काहे urgent କରୁଛନ୍ତି?
350 for 2 years or
2 years.
Happy year पड़ेगा.
Huh? You are.
ना ना এটা
देखो. नहीं बेशी अच्छी.
ना कितने এটা টিচার স্টুডেন্ট
আহা
এটা দাও
Okay. Over 48.
48 7 years আছে
48.
48 I am there. 48 I am there through online.
47. Put 47 na 48.
না এই যে 148
148 na.
in half the
47 year of biar out section 2 years punishment
2 years.
48 my lord, I am praying 48 may be posted to after vacation because I have not been able to my lord, connect the party because of the fact that it has come up after a long gap. This conviction under 47 of the Bihar and Orissa Excise Act SI for 2 years. I'll just find out. Depending on the conduct, I will definitely pray with your lordship for modulation of the sentence.
And let it be in the list. You keep on finding out. Who knows? By Monday you can find out.
As your lordship pleases, but I was since only 5-6 days left. I was praying for reopening week. Your lordship.
I want to finish up this matter already undergone or something. We'll do and finish it up.
My lord, that's what I will be praying for. Let me just find out. As your lordship pleases, let it be in the list.
Let it be there in the board.
My lord.
Sorry, my lord, 125, my lord.
125, what happened?
Yes, my lord. But she is not interested in pursuing this case 490 other offense. She is only interested for maintenance, my lord. Challenging that order, she has filed the writ petition. That has also been dismissed, my lord.
Oh, service is not a petition.
Yes.
Service no. Upon through IIC corridor. IIC, which police station? Despite notice, the opposite party number 2 has not appeared. Let the opposite party be served through IIC.
Lucknow.
Noapada. Already did jail.
May payment till then no interim.
She is not bothered about you. Why are you bothered about her?
Because a criminal case has been lodged against me.
Nobody is bothered about you. 498.
A cognizance has been taken, my till that.
Yeah.